All right. Good evening, folks. Welcome to Monday Night Law. Kirk's Law Corner live. Here we are. Here we
It's
are.
a
We're here. We're here.
it's another Monday night.
It's a moon day.
Oh yeah.
Welcome to
Oh,
the new month. Weather's changing, whether you like it or not.
right?
100% chance of weather. I can guarantee it.
Ish.
Oh, I can guarantee 100% chance of weather,
Yes. Yes, and it
whether
is
you like that weather or not.
ex-
It may be sunny. It may be raining. It may be snowing. It may be freezing ass cold. But yeah, guaranteed there's going to be some weather.
right. Ish.
Like there's cool whip. There's weather.
Uh
That's the other weather.
that would be
Weather.
that climate change that's all shit made up.
Right.
Or did
Right.
I did I say that out loud?
Yeah. Well, that would be the global warming. Climate change? Well, of course. It's natural. It's gonna
Happens
happen.
at least 4 times a year.
Right.
can set your you can set your farmer's almanac by it, or ish.
Yeah.
Oh,
The weather does change.
honest to God.
Heck, I remember a few years back, right around my birthday in July, it snowed here in Idaho. And it's supposed to be, hottest time of the year here in Idaho in July. I mean, it
Hey,
was
I
what,
remember hunting for Easter eggs in the
6 years
snow
ago?
when I was like little kid. So, oh yeah, yeah. That's why I okay. Climate change.
Okay,
What's
buddy.
it? What's it
It's
changing
change.
to? You know, we now have a space force. Okay, let's see. What say you, Space Force? Like Kirk said, 100% chance of weather.
That's right. Yeah, it's changing from insulated pants, long johns, and long sleeve shirts and thermals to shorts and t-shirts,
Oh,
depending on where you're at.
pretty much that way all year down here, with the exception of what I call hoodie season.
What,
Blue
Christmas
jeans and
time?
hoodie season. Yeah, blue jeans and hoodie season. That's really about it.
Yeah.
So
But
I'm just getting
it's
scared.
freezing over there in Wisconsin right now, 30 degrees over there.
Right. In case any of you noticed, the studio behind me obviously has changed. I want to say, obviously, thank you to those who have been donating. I'm trying to include as many of those donations on the studio here as I possibly can, including the bookshelf over here to my immediate left. So that came from a local business. So I want to say thank you to them. And one of these days, when this is all said and done, I'm already preparing the list of donors. So um, we will be, saying thank you properly to them. For now, they've wished to remain anonymous under the circumstances. Quite frankly, I don't blame them in such a politically charged climate. So, but, hey, they're like the Declaration of Independence basically says, those who have the duty to respond have the responsibility to respond. I responded. It's what the emoluments of that office say, right?
Right?
Been through that about 100 times. So, you know, as long as that emolument hangs on my wall, I'm technically duty bound to do what I do. That means when I'm on the clock, I'm doing this job. So when do I get off the clock? I guess that's the real question.
I know.
So,
When do we get to go on vacation where we don't do Monday Night Law, Wednesday Night Live, or Friday Night Fun Night for at least 1 week?
yeah, just one. I mean,
Ha- Haven't had a week off in 3 years, 4 years.
it's amazing. I look back to this and I think to myself, well, if I've confirmed anything, I've confirmed the reason why I'm no longer married. Remember, that is, oh, that's right. He works too damn much.
Uh huh.
Okay, guilty.
So,
Guilty is charged.
a brief update on field. Far as I know, the hearing that was scheduled for this morning was moved to Friday, and he's still incarcerated. He hasn't been bailed out. So,
Oh, could that be
um,
because they're trying to make a deal to get him to swear to something that, oh, it'd be potentially some shift made up?
well,
Hmm.
they want you to just go ahead and well, we've got these charges against you, and you're gonna go away for a long time. But now that we got you in jail and all locked up, and you can't get out to access any good, solid legal counsel or anything like that, um, will you just plead guilty, please, so we don't have to go through all the formalities of proving jurisdiction and proving our status, standing in jurisdiction in law, and what law we're using, and the fact that we subverted the law. Your right to a grand jury indictment, your right to have us prove to the governor for an extradition warrant that you were physically in Broward County
Hmm.
or
Because
anything like that, because we don't want to have to prove that we actually followed due process of law. Even if we had a legitimate claim against you, we don't want to have to prove that we followed due process of law, because you didn't.
exactly, right?
I'm
And
sure
here's the
Agent 19 got a hold of you guys and told you that, in that Zoom meeting that Agent 19 probably failed to put out there. I don't know. I'd never watched the video that he put out, but I know what was said in there, and I know that we schooled his ass and I showed him the law. And it says that you have to have a grand jury indictment for any crime over 6 months.
That's right, because
Even
the
the
actors,
Florida statute upholds the same thing in regards to um, extradition.
well,
The
let's look
first
at,
element is they have to prove that the crime scene was in the territorial jurisdiction of Broward County, and
mhm.
they can't do that.
Well,
They should
remember,
have done that before they got the governor to sign on this warrant, which I still haven't seen. I've seen some documents, but I haven't seen the governor's warrant with the governor's signature on it. Doesn't
right.
exist yet. So how did you extradite a man from one state to another without an actual lawful governor's warrant? I mean, there's paperwork there, and you make it seem like you followed it, but the warrant is not there. There's no governor's warrant signed. I don't see it. And then where's the grand jury indictment? The governor's supposed to verify the location of the crime scene, that it was actually in Broward County, not shit made up out here that's on entertainment purposes only, and a grand jury indictment is required by the Sixth Amendment.
Uh-oh. You mean that basic Magna
And
Carta due process? Oh, shit.
bingo. And I mean, there's even case law behind it, which I read to Agent 19
Case
while
law
he was
my
in
ass.
here.
It's the law.
It is. And that's why I
Case
was
law.
going off on him.
No, no. Don't bring me the starry-eyed deceases bullshit. I'm talking about the letter of the law here,
Yeah.
right? So
Well, this
if
is
we're
that.
talking the letter of the law, remember every one of these actors who has done this, which pillar of law are they acting in? Which one? It ain't the first, it ain't the second, and it ain't the third. Which pillar? And the answer is the fourth pillar. So that said, what do we know about foreign emoluments since the impeachment mechanism bullshit? What standing do foreign emoluments have? Oh, that's right, none. So when we file our petition, we are filing against somebody without doors. They have no standing, right? They are out at sea at law, right? So, which is my one of my most hysterical jokes in that. So let me get this straight. You paid almost $300,000, or going to continue to pay plus interest, which is probably compounding as we speak, to not have any standing in law. What? And this is called intelligence, right? Oh, Jesus.
Mm,
Woo. Yeah, I think I'll continue on with my real sciences, where I fix machines and, you know,
mhm.
with you can't see it. Here's that hammer that I don't have to hit my thumb with to know that shit hurts, right? That's part of my new studio, by the way. That's my tribute to
The
Kirk,
useful
this
tool.
the useful tool.
So I want to clarify something here. Yes, the other day I said sarcastically, "Oh, Fields out of jail. Yep, everything's good." No, the reason why I said that was because what was going around was Margaritaville was saying that Fields was out.
Right.
Everybody, I'm like, "No, Fields not out. Not that I'm aware of. He's still not out. Not that I'm
Not
aware
that
of."
I'm aware of.
And you know, this is where people not paying attention fully. When I
Mhm.
said no, that's no, I made that up, right? I'm like, no, because of the trolls out there saying what they were saying is why I said that.
Mhm. So, we have again, we're
So
going
I
to
I,
talk
I
admiralty
apologize for the
jurisdiction.
confusion for uh, saying that Field was out. I do apologize for that. So maybe I'll just refrain from.
God forbid you'd make a joke. Damn you.
Yeah, I don't know if it was in good taste or not, but I was trying to make fun of the trolls, and
Oh, that was Friday night fun night.
well, yeah, that's a given. But I do apologize, folks, that I probably shouldn't have said made a joke out of the fact that Fields not out of jail yet. But I do want to remind people about the depth of corruption we're dealing with here, and specifically in Broward County, and the people we're dealing with. These people, uh, I'll just flat out say it, they don't know the law at all, and especially people trying to say that I don't know what I'm talking about. Yet here we are showing the law, the letter of the law as it is written. How could I possibly not know what it says when I'm the one that's reading it, and we're the ones that's sharing it with you? I mean, give me a break, really?
Well,
But
and
anywho,
again, now here's what we're talking about. What they're pissed about is we're calling them out for their corruption of due process, right?
hmm hmm
Because they're the ones that don't even know what the hell due process of law even is in a republic. Okay.
right?
And so let
We're a
me jump in.
republic. Thought we're a democracy. No, we're a representative democracy. No,
What
no,
color is the
we're not.
sky in
We
your
are a
world, bro?
constitutional republic where the Constitution institutes government. That's
And
how
it
you
also,
get the consent of the governed.
right. And it also limits government, right?
Bingo.
So,
Well, without that Constitution, we don't have government at all
well,
because
that's
the
right.
Constitution institutes government.
And this, what we already know, again, because of the impeachment, this Sharia state has no standing. So, when anything that says state versus you don't have standing. Get the hell out of here. So, because that's we've already beaten that, and it was just hence the whole back and forth of all you know what role like committees play in the process, for example, right? Are they lawful? Are they not lawful? Right? What's again, what's the intended purpose of the committee? What's its job? What's it's there to do? What is it there to do? Well, once it does its work and reports to the entire quorum, and the quorum, the proper quorum, right, takes its vote, okay, then that's the assembly of the proper quorum, and the committee has done its job. So, but knowing and understanding that, what I'm looking for here is this section in the book on, yeah, let me just share it.
Oh
Uh,
boy.
there
Yeah, I heard
is,
about that, Jay. That Hillary Clinton had to. She was called in to do a deposition. They're going to be sitting her butt down and asking her some questions.
right? Well, and again, what was during the 2018 midterms, right? Anybody who was here in Florida knows we had a serious election problem, right?
You did?
So because there was a serious election problem, somebody's trying to steal power that they and exercise power they don't have, right? That would be an emoluments violation, would it not? What's the name on my door? Loss prevention, clause. Okay. So when I filed into the legislature under Chapter 31, voting and nominations and elections, and said, we want this investigated, because they're like, well, I don't know if we can investigate. I don't know if we can investigate. Oh, yeah, you can. I'll order one. That's what I said. I'll play bad guy. I don't give a shit. I don't, I'm used to being the bad guy. So that's what we did. We ordered the investigation, right? Are these bad actors? Are these good actors? Who are these actors? Okay. And one such process that I've gone through more than once, I'll bring this back up for you guys just because I'm that kind of guy, is the parliamentary inquiry, right? Well, whoops, didn't want to do that. I want to do this. Okay. What is the purpose of a parliamentary inquiry, right? During the sessions of a legislative body, members may desire to obtain information concerning the procedure or business before the House, right? House or Senate. The requests are not technically motions, but for convenience are classified with them. A parliamentary inquiry is a request for information from the presiding officer with respect to procedure concerning some question before the House or that may be immediately brought before the House. Okay, so again, we have this election problem. One way to enter a very quick enter into the quorum, right, is to enter a parliamentary inquiry. For example, would you like me to um, administer a request for investigation into the emoluments, right, for potential emoluments violation of the Broward County Elections Commission? It's very simple, right? And oh, by the way, there's no docket to this process, right? This is on paper the same as me walking in there saying, hey, would you like me to send you guys a letter? Right? Well, what would one of those letters look like? Um, one of those letters, I've shown those just for the sport of it. Let's look at one of those letters. So that would be, I think I still have it right here under subsidiary motion. Yeah, here it is. This was just a basic subsidiary motion, no special flavors, no nothing. This is just the
Can you
man.
can you blow that up? Thank
Yep.
you. You're
Yep.
already on it. Never mind.
Just the man. This guy right here. Right. And I'm just respectfully submitting to the 116th Congress for the United States of America. Right. Mason's subsidiary motion number 23. We've already been through that. And there's an example of a way to do this. Right. This was a subsidiary motion. I could have changed this to a parliamentary inquiry and entered it anywhere I wanted. Right. These are questions of law. There were findings of facts, certainly. So that certainly denotes a question of law, right? As you look around the emoluments of your office, right? Um, you know, are emoluments of statutable plunder the legacy for which I am to be remembered? Would that potentially give um, Madam Chair Dianne Feinstein a moment of pause? I would say it did, because now who's she sitting next to in committee? She's sitting right next to our good old buddy Lindsey Graham. So, you know, again, this is how
Mhm.
you reach across the aisle and say, do you know you were being used as a tool? Huh? Yeah. Somebody was using you to further their own agenda, right? And, I went down through and I showed the isosceles triangle with the bar in the middle of it and the math with the whole, 60 degrees and all that fancy schmancy BS. Makes perfect sense, right? So
Mhm.
9/11, right, was what, 9/11 1941 was the first date of construction of the Pentagon. 9/11 2001 it was attacked. 60 days, 60 years to the day. Do you believe in coincidences? Because I sure as hell don't. So,
So just want to put the word out here. If you've been subjected to any of the cyber stalking, doxing, phone calls to your boss and lost your job because of lies from these certain particular trolls, working on gathering information on these people. If you want to send me an email at kirk.eclausellc@gmail.com and put in the heading cyber stalking. If you're willing to write an affidavit of truth signed under penalty of perjury, if you happen to have the particular video downloaded, saved, however you have it, make sure that you have the minutes mark of the video and the video to go with your statement of facts. Again, affidavit of truth signed under penalty of perjury and notarized. So from my understanding, I received an email here a couple months ago about possibly somewhere in the field of 250 plus people that have been subjected to this cyber stalking, doxing, and things like calling your boss and getting you fired by making false statements. Okay. These people have been doing this for 10, 11 years, documented
right,
video wise. There's sufficient evidence against these people of what they have been doing is almost exactly what they're claiming that Tim and Field did. So,
right.
turnabout's fair play, but we're going to follow due process of law. We're going to follow the law of process that's due to them. So, if you happen to know anybody, pass this information on to get it together, and let's follow due process of law and give them the process that's due to them, and we will properly file a complaint.
I'm going to pull one of those up right now.
What's
Because
that?
I'm going to pull one of those up because I've actually done one. So,
Well, look at the treatise on arrest and false imprisonment. There's your complaint. That's proper form right there.
well, and
Who
again,
did what, where, and when. And you don't even have to worry about the law side of it. I just want the who did what, where, and when, and the video or any paper evidence, any kind of evidence that you have to support the claim. And if you're going to do a video, make sure you do the time points in your statement of facts. Okay. So that way, when I go to submit this to who we're going to submit this to, that they can look at it and go, oh, this is the video accompanying this statement of fact. And at what minute and second mark you're talking about that this statement was made. So, no, Nancy, I'm not letting none of this get to me. I know that I tell the truth. I know that I speak the truth. I know that I educate people on the truth, the law as it is written. I know that I'm also human and I do make mistakes, right? To error is human, right? So, uh, you know, but I have at least a modicum of integrity to admit when I'm wrong and go, holy, yeah, crap, I'm wrong. So, yeah, and any kind of chat rooms that you were in that you may have saved and seen some comments of who is saying what, where, and when, any kind of piece of evidence that you have where these people are working together, where they have been making videos about you, anything that they've been doing like what they're doing right now. So I think this needs to be redressed, and I think quite a few, based on the email that I received from one woman, stating that she had evidence of about 250 people that have been subjected to these people's actual cyber stalking, doxing, and all that stuff. So, this again, right back to the Democrats' playbook of, well, we'll accuse them of what we're actually doing. And then we'll put it out in the news, we'll just make it up and put something out there and everybody will just start believing it. And that's essentially what they're doing. Oh,
Of
E-Clause is
course.
a fraud. Yeah. Is that right? We're why is there a license issued by the Florida Department of State that can be easily verified? We've showed it to you. We've shared it with you. We've showed you the website to go to verify. I mean, I don't understand the problem. I guess we're
Okay.
dealing with either an IQ problem, uh, or a corruption problem.
All right. Here's the remember, right? One of the things that we've done is we've opened a few doors. Okay. And one of those doors, okay, this is the complaint. Here's the email. This is actually from my Facebook page. So you guys can go check this out. And here's where it is, right? Because I am a lawfully created emolument, a business, as Kirk said. There's my business license, right? There's the numbers.
Yeah,
So I'm entitled to these protections under the letter of the law, right?
as well as that E-Clause is a registered trademark.
That's right. So again, this is
Can't go
one
out there and
such,
try to use E-Clause's name to create websites and that kind of stuff. That's
oh, yeah,
trademark
for
infringement.
defamation. Oh, yeah. So again, you know, I've already proceeded with the process, right? Small business request for assistance should be mailed to. There it is right there. So now there's also a hard copy form which I did print and send, right?
Right.
Remember the white envelope with the corporate stamp on it, right? So that's part of the process, right? So again, you want us to submit some of these things. Now granted, when we're talking about a specific set of actors, right? If it's something related to your case specifically, like your ex or whatever, that's a whole different animal. All right. That's not this process. This is specifically against the actors to which Kirk is referring because I've
Well,
already
no,
opened, well, I've already opened a file on this guy.
this
So
this is not what I'm asking for.
no, no,
What
no.
I'm
You're right.
asking for is a written statement of facts,
Right. But I'm showing
proper form
people,
of a complaint.
right. But I'm showing people what's going to happen to those complaints when we get them because I know they're going to ask. Right. So
Right.
how do these complaints that we're going to send you get submitted? What process? And the answer is right here. So, again, that's why I said this is one of the reasons we do this show. Okay. It's not just, okay, we know the law, we know the process, we know how to do it lawfully.
Hmm.
Okay. So, am I going to go banging on a judge's door? I don't have to do that. I have emoluments for that.
Well, and essentially the way we're going to really do this is through due process of law that anybody can follow. But
Mm-hmm.
because of what we already do and the contacts that we have and the channels that we have, uh, you know, we're
Right.
not using our position of employment as an advantage here because we're following due process of law and
Mm-hmm.
we're going to be properly reporting to those in the proper positions of emolument. And we're going to instruct our representatives to do their job and investigate this stuff.
That's right.
Go
So,
for some
again,
sealed indictments. And when the time comes, those
mm-hmm.
sealed indictments will be unsealed and they'll be arrested and away they go.
That's right.
Based on the
Because,
evidence that I'm aware of, you guys think you can do this to Field McConnell and the process that you guys used? Imagine us following due process of law in accordance with the letter of the law. What's
well,
going to happen to these people?
what did we just decide about that Sharia state? What standing does it have? Oh, that's right, none. So,
Not in any
just,
state of being in this nation called America.
just saying. So,
That would be foreign to our form of government and repugnant to the
right,
law
and
of this nation
right. So,
called
what would
America.
be right? So, because the fraud and trickery happened, right, while Field was doing something else, while Kirk was doing something else, while I was doing something else, shit, while you were doing something else,
Right.
you know, um, they can't bring something into being that isn't lawful, right? So this is what that cleanup looks like, right? Because remember, that was back in the 90s. Here's the good news. There's been more than one um, House and Senate have been convened since the original trespass. So guess what? They have. Oh, wait a minute. We've got a mechanism legislating for people in all cases. Oh, bullshit. We can't. Oh no, I'm new to this game. I can fix that problem, right?
So
So
I I got the PDF up for the common law pleadings. This
ooh,
book right here.
oh, good deal. I'm
Okay.
glad you finally found it.
I've had that PDF for a long time, remember?
I know, but you looked for it and couldn't find it on Friday Night Fun Night, I think, wasn't it?
That's not what I was looking for. But
Oh,
anyways,
okay. You're
um
gonna share, right?
I am going
Good.
to share the PDF that's all messed up, but because I have the book, I have a cipher here
Right? You're gonna have to decipher the code.
because the way the book is written and whoever scanned it, I have a pretty good idea that the way they scanned it, because you have the main bold print and then all the fine print is the footnotes and stuff. That's the reason why it changes font within the PDF, and
Right.
it's because it's putting that all together.
Right.
And this is where you come in with the bold print. Right in the middle of a sentence, it stops, goes into all these footnote stuff, fine print stuff, and we're supposed to pick up in the next the rest of the paragraph where it would go to a next page or something. You got to hunt for it, but you know, I figure it out to some certain extent. And you remember this, like crap. It's been almost 2 years now. It's been in Kirk's Law Corner, and I said, hey,
Right.
we need to be reading this, and I
Right.
racked my brain trying to read this,
Mm-hmm.
and then I found the book.
Right.
Of course, it was $200 for this one book, and if you can
Right.
find another one, good luck. I
Right.
just happened to get lucky and find this. It's a hardback. It's the original book they used in the day for law school.
Right. Which
So
reminds me,
we can't get
um,
away. We can't get away from the common law,
right,
the
which
common law
reminds me,
rules of procedure.
right, which reminds me, in order for Kirk and I to be able to do this, right, again, the donations and the way you guys are helping us get this stuff set up, right? This is how you got to help Kirk out, right? And you know, so he can keep these materials coming, right? Um, I just got, like I said, I got this bookshelf. I got what, 3 new books, and they've been integrated into the process. I haven't had a chance to get much scanned out of them yet, but I got a brand new thesaurus from Peter Heltzer. So thank you to whoever donated that. And if you guys want to jump in on something that I'm doing specifically, this is how to jump in. This is how to donate to me. A little quick update on we got movement out west. Out west, it looks like it's a go. Certificate of good standing is on its way, and that will be posted the same way the one here is from Florida as soon as I get that bad rascal in the mail. This way, those numbers, right, will be available for you guys out in California. So, um, again, here's the states that we're working on right now. Again, you can either Kirk or myself, right? Obviously, District of Columbia, but we've been in Utah, we've got Michigan, we've got Oklahoma, Florida, Texas. There's Kirk, Idaho. uh,
What'd you just call me?
Idaho, bro. There's Ohio. It's high in the middle and round on both ends.
What you talking about, Willis?
Right? That's high in the middle and round on both ends. California. Or no, wait a minute. That's New York. Oh,
Ohio.
Ohio's on the lower right corner there. Sorry about that, New York. So, but there's New York in the center. Ohio is over to the right there. But
Yeah,
anyway,
say New York needs to be the jackwagon there.
yeah, right. Yeah. So,
Okay.
yeah, they're running behind, man. Come on, New York. Hurry up. Waiting on that paper in the mail, dude. So,
let's see if this, yeah, this keyboard, I can make this
There it is.
mostly as big as possible.
Mostly.
Mostly.
Ish.
I was waiting for somebody to try and say it though.
Yeah.
That is not proper English, and I can't get it to go.
Right.
If I go there, it's too big. There, it's too small. Oh,
Don't
wait,
touch me
I
there.
can
You
do
get
this.
me all excited.
Is it this one? Well, shit, it jumps from 200% to 300%.
Go 250. Type it
Yeah, how
manually.
do I do that? Okay, how do we do that?
Just type
250.
250 and hit enter.
That'll work. I think I can center that out. I'm
There you go.
trying to make this mostly as big as possible ish. Mostly.
Sort of, kind of.
Sort of, kind of. So, there we go. Okay. This is from this book right here. This is just in PDF form, but you can see how it's like right here, relative posi. So where do you pick it up? It looks like it goes position of which will appear from a typical body. But yeah. So this is formal parts of a declaration that has to be in the complaint, part of the complaint. But I want to go back up. That's page 93, kind of to the beginning here, because we got to comprehend here. And they say it right here. There's no way to get away from the common law. Even right here. They have also overlooked the fact that there is greater similarity in the essential principles underlying pleading at common law. So anytime you see at law, it actually refers to the common law. So at common law, inequity under modern codes and practice acts, and even under the new federal rules of civil procedure now in effect in the federal courts, than is generally realized. Okay. I don't know. This is right here where it's talking about it. Legal education at the expense of litigants, students at law, and the public welfare generally, by proclaiming the concept that all that has been gone before in our procedural ancestry should be regarded as obsolete and worthless, and is not to be considered in terms of modern pleading and practice. Aid in terms of modern legal education. Those who take this limited view have clearly confused the real merits of the common law system with those portions of the enduring principles of the legal procedure.
That almost sounds like a fundamental alteration, but I'm just going to let it go for now.
Right? How about this particular part? Moreover, the essential elements of causes of action, which must be pleaded, have not been abolished by the reformed procedure. But yet that's because procedure is not law. So you can't change the law through a rule of procedure. Okay. So now we comprehend that. Because we're talking about principles, right? Here's also the rule of court, the Shipman Handbook of Common Law Pleading, which is even an older one. I'm going to go back down to page 9. It's like 93. Oops. Well, not oops, but did change. There we go. Yep. Pretty much we're getting right into that particular part there. In general, formal parts of the declaration. The first pleading in an action is the plaintiff's declaration, which is a statement in legal and methodical form. Now, this goes right back to exactly what I'm asking people to do out there for these trolls, right? You've been subjected to these people. I need this methodical form of all the material facts constituting your cause of action. Plain and simple. Statement of facts, which in the form of a complaint becomes a declaration of facts. You're declaring, right? You're declaring your right to a cause of action, and which I'll get into on page 97 here of the PDF. In the book would actually be page 86, chapter 4, section 21. You'll see that here in just a minute. But I wanted to back up to kind of like the beginning part of this particular part here. This is explaining the offensive side, essentially. And you on the defense need to know this is how you why you do a motion to dismiss for failure to state a claim for which relief can be granted. Because if they can't declare their right to a cause of action, they don't have standing in law. You got to have standing in law first. So this is why it says what it says, as it says, as it is written. Got to have those material facts constituting the right to a cause of action. It consists of the following parts: caption or title of court. Now, caption is the top portion of your document. So, when we talk about before is, all that, the letterhead stuff that, on all of your legal documents. Okay. This has to be in proper. I'm starting to bust their ass on improper documents, such as the warrant in Fields case. Not lawful. It's not in proper form. It says, legislature says a warrant must be substantially in this form. And it's a lowercase s state of Florida. Oops. That makes that fake warrant even faker. But anyway, so the caption is the top portion of your documents, the title of the court, the case number. We'll get into that. See, look, the venue, the body, or statement of the cause of action. The parties haven't been brought into court as a result of service of some form of process. Okay, some form of process. Due process of law requires an affidavit of truth signed under penalty of perjury, claiming your right to a cause of action. Okay, that's see the Fourth Amendment. All right, so here we go. This is why in your motion to dismiss, insufficiency of service and insufficiency of process are also grounds for dismissal. Because if you violate the fundamental principles of due process of law, you automatically lose jurisdiction. Right there. You drop the ball on the process that was due to your fellow man, you lose. You got dirty hands. That's why you have to remain in honor at all times, and don't get your hands dirty, right? Follow the law. Follow due process of law. Because if you're not following due process of law and you're claiming somebody else isn't following due process of law, you're no better than they are. And this goes right back to the fundamental principle of the Bible when Jesus says, those without sin may cast the first stone. Those with clean hands may claim their right to a cause of action. That's actually what Jesus was talking about. Not that, just because because we're all sinners, right? I mean, not one of us is without sin. So that would mean that none of us can pick up a stone. None of us can claim a right to a cause of action. Not in law, not the common law, the real law. You just got to make sure that you have clean hands when you go to pick up that stone, and you better follow the process that's due, because you could lose simply not by not following the process that's due. Okay? So, here we go. The next step is to show by pleadings duly recorded. Your court of record is your documents. The nature of their dispute. Imagine that. You have the right to know if this is criminal in nature or civil in nature. It's still the same process. It's a civilized process.
You mean that basic Magna Carta due process? You have the right to face your accuser. Oh, I'll be damned. Here we
And
go.
you
We
also
keep
have the
going
right to
back to
demand the
that.
nature and the cause of action,
There you go.
because that dictates what kind of trial by jury you demand.
That's right. Now you know why I love this job.
I love my job.
Right.
And the first step in this direction in personal actions is for the plaintiff to file his declaration, which is a statement in legal form of the plaintiff's cause of action. That probable cause pursuant to the Fourth Amendment. The Fourth Amendment requires an affidavit of truth, right?
There
Sure
you go.
does.
Oh, yeah.
They go, oh, well, we had probable cause. They had probable cause. You didn't have a right to a cause of action,
Yeah. You had
and
probable cause to
you
what?
you
Right.
probably had a cause of action. What do you mean you probably had a cause of action? Either
Right.
you did or you didn't. But
Yeah.
that's the word salad they play.
Right. I probably
Probable
had.
cause means you've got that affidavit,
Yeah.
or later you're going to get that affidavit. Let's say you got a phone call, right? Breach of the peace. You're a peace officer. Police officers don't exist in our form of government. Sorry. So you're a peace officer to handle disputes of breach of the peace. Go read the treatise on arrest and false imprisonment. The actual common law dictates this, that you are a peace officer. No such thing as a police officer. It's actually being mispronounced. It would be a policy officer,
Right.
and that would be a declared act of tyranny, erecting a multitude of offices, sending hither swarms of officers, police policy officers, to harass our people and eat out our substance with bills of attainder, pretended acts of legislation. That's what the Declaration of Independence calls them, pretended acts of legislation.
That's
That
right.
would be taking subject matter jurisdiction into your own hands and just go ahead and making whatever legislation you want. But again, we go back to uh, hmm, anything in the Constitution or laws of a state to the contrary or notwithstanding.
That's right.
Marbury versus Madison, 5 U.S. 137. Anything comes in conflict with the Constitution is void for any effect from its inception,
Mm-hmm.
not from the day you go to court and brand it unconstitutional.
Right.
Why? Because fraud vitiates everything from its inception.
Right.
U.S. versus Throckmorton. That is the leading presiding case in history that establishes, well, I would say establishes fraud, but establishes the judicial branch's doctrine of fraud.
Yeah.
And how, no, fraud doesn't have standing in law at all, in contract law, in any kind of law, and it's wholly void for any effect.
Mm-hmm.
Don't be trying to use fraud.
Right.
Okay, so and there we go. We even talk about Lord Coke here for a second. The plaintiff's cause of action. In the ancient real actions, the first pleading was a count. The declaration was, according to Coke, but an amplification of the general charge contained in the original writ, setting forth in greater detail the circumstances involved in the plaintiff's cause of action. According to the custom and practice of the court in which it was filed, And depending upon the form of the action in each case, the substantive requisites of the declaration differed. But all declarations were alike in that they contained 5 formal parts, to wit, the title of the court, the venue, which would actually be territorial jurisdiction, the commencement, the body, or statement of the cause of action, and the conclusion, the character and relative, here we go, jump, position of which will appear from a typical body, the body of the complaint, the body of the declaration. Okay. Form of declaration in trespass on the case, something non of substance. Subset. See, okay, here's the caption for you. There it is. Caption or title.
Right.
In the circuit court, blah, 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 blah. And see, this is all messed up in the book. I think it's laid out correctly, straighter. But as you can see here, you got uh, the venue, the state, the term, the court. Those words aren't actually there. They're just giving you the illustration. And then the body is the declaration of itself. What is it you're complaining about? What was, again, we'll get into that, the conduct. What was the right? What was the conduct that violated that right? And what are the damages? That would be that part, right? And the conclusion. It appears that the damages are in the sum of pay up. With the form of a specific declaration and assumption before us, the declaration must now be examined. First, with reference to its formal parts. Okay, this is where we go in and we attack the fact that, okay, when you do the state of in all capital letters versus, that is not proper. So there's grounds for dismissal. The complaint's not proper. The all capital letter state of blah, blah, blah is a fiction, and it's more than just a fiction, it's de facto. Because in our form of government, that doesn't exist. That's not proper English. And then the legislature dictates what that's supposed to read right there. Because you can only sue on behalf of a principal, one of the people, as a public prosecuting attorney, right? And they're supposed to be prosecuting the public, not the people in the private. You're supposed to be prosecuting on behalf of the people in the private that have been trespassed by someone in the public, such as McDonald's, or I don't know, a judge, another prosecutor, a bar member, a social worker, a police officer,
Or
or any
somebody
elected
some,
official.
somebody guilty of heinous crimes, people versus whoever the actor is, right?
Bingo.
Who was it that just went down? It was People versus Harvey Weinstein, as I recall, was it not? If you've read
Man,
the case style,
the case style was proper, was it not?
there you go. That's what I'm talking about,
Even in
baby.
my Idaho Constitution, it says the people of Idaho on
Right.
behalf of the people of Idaho.
Right. So if it's criminal in nature, it's people versus X, whoever X is, or
Yeah,
whatever X is.
because people is mono and plural, right? I am one of the people. There's a whole group of people over there. That's it. It's people can be used in mono and plural. Okay. So, Arthur Brown, plaintiff. Get my bearings here, my mouse bearings on that one so I can see it over here. Arthur Brown, plaintiff by William Johnson, his attorney. Notice it doesn't say bar member. Notice there isn't any bar number there. Anywho, complains of Clarence Dowell, defendant, who has been summoned to answer the said plaintiff in a plea of trespass on the case in Assumption. inducement. For what, whereas on the what? Here's the when. 16th day of January, the who, what, where, and when. We're going over the 4 W's right here, right now. With the said defendant to buy of him, to buy from him. Now remember, this is a little bit older, so. And the said defendant then and there at Chicago in the county aforesaid, right? Bargained with the said defendant to buy of him, and the said defendant then and there sold to the said plaintiff a large quantity of corn, to wit, 1,000 bushels at the price of 60 cents for each bushel thereof, to be delivered by the said defendant to the said plaintiff in the week then next following, and the said plaintiff's elevator in said city, and to be paid for by the said plaintiff to the said defendant on the delivery thereof as aforesaid. Do we get enough said in there? Kind of
Yeah,
corny.
ish.
All right. So there's a quick statement of fact right there.
Right.
There's no fluff. And that's one sentence. It's a one statement of fact. And in consideration thereof, and where am I at? Find me. Here we go.
Sort of,
And
kind
in
of, maybe.
consideration thereof, and that the said plaintiff had promised said defendant at his request. So he's laying down the body of the cause of action. What happened? The who did what, where, and when. Now, this here, in my mind, would still be itemized in a separate itemized statement of facts. This is the way we're doing them now, but I'm sure it's in here somewhere. It's kind of all messed up. So, but anyways, with the form of a specific declaration in assumption before us, the declaration may now be examined. First, with reference to its formal parts. See, this is teaching us how to dissect someone's complaint. Declaration, form
Right.
of a complaint. Is it in proper form? Because that would be the first thing to look at, right?
Mm-hmm. You would think.
Is the complaint in proper form, the proper venue, territorial jurisdiction? If you weren't there and the crime scene isn't there, then that's not the place of the trial. You got to
Right.
go to where the crime scene happened. And I'm sorry, but the internet is not a crime scene. It can't be a crime scene.
Right. You mean one of them there fictions?
Well, guess that would be part of the S in laws now, Space Force.
Right.
Cyber space.
Right.
Can you give me the latitude, longitude, the meets and bounds of cyberspace?
There was a show
Where would
called
that venue be? You guys like to use venue. Where would the territory be? Give me the latitude and longitude, please.
Uranus, maybe? Oh.
Yeah, there with the
Sorry.
shmew. Shift into first gear made up.
There we go. Kind of
All right. So with the
ricochet it
form,
off Mars around Jupiter, bounce off the rings of Saturn right to Uranus.
right?
So,
With the form of a specific declaration as something for us, the declaration may now be examined. This is what I try to recommend to everyone out here. Whatever you get served with, summons, whatever it is, whatever document gets handed to you, look at it. From the very first letter in the upper left-hand corner, because we read left to right, top to bottom in America, in the English language. So you're going to want to read every single letter, word that's on that piece of paper. Is this thing in proper form? Because this particular document must be in proper form, or it's grounds for dismissal with prejudice. So we're going to reference to its formal parts and general compositional and physical structure. Oh no. Does that mean if you don't have your document in proper format, proper structure, that it could be dismissed? Why, yes. Yes, it can, because that's not proper before the court. You're going to claim sui juris, you have to be sui juris, which is one of the elements of sui juris, is what? Perfectly capable of handling your administrative duties.
Mm-hmm.
It is your duty to make sure that your documents are in proper proper format.
Right.
So the other man that you're going to send this to can read it, comprehend it, and understand it, and then respond to it.
Mm-hmm. Can I ask a question?
Yes, sir.
Why is it that we have to have emoluments of our own to do this? We're supposed to have this right, right? These are those rights retained by the people,
Correct.
right? Okay, just no, or no. I was expecting you to say no left, but anyway,
Right.
um, left.
Well, I mean,
But
at least in our republic, we're supposed to.
well, there you go, right? So again, you know, are you complaining against one of those multitudes of new offices, right? Are, you know, they're claiming, oh yeah, that's a private corporation. That's why I said, you want to play Monopoly Corporation? Oh, this is going to be fun. So, and they don't like it when you play Monopoly Corporation with them. So, what Kirk is telling you is absolutely true. It, to me, it still begs the question: why do we have to have emoluments of our own to tell these people what they're supposed to already know? To know a thing and to be bound to know it are regarded in law as equivalent, right?
Yep.
At least that's what I thought. I mean, I'm just saying. So
Yeah.
anyway, I just had to kind of throw that. You know me, I'm really good at that conundrum shit, right? So
Right.
yeah,
We both are.
right. So I just everybody's brains out there train wrecking, going, that son of a.
Right.
But anyway, continue. I just had to have some fun.
All right. So here we go. The parts are general compositional and physical structure, the format. And secondly, with reference to the usual factors, there's supposed this is supposed to be common in with the declaration, usual factors and rules which govern the statement of a cause of action in any form. The problem of stating a cause of action in terms of each of the 11 specific common law actions will follow in the latter chapters. So there's 11 specific common law actions. Pretty simple, really, right? I mean, essentially, common sense, right? Why am I not? Oh, because I'm using the wrong mouse to make this screen move that won't make that screen move. And we'll do this.
Did you break the
Okay.
internet again?
The problem of stating cause of action in terms of, okay. The caption or title of the court and term with respect to the title of the court consists in general of a superscription of the name of the court. Thus, notice how it's written here in the Circuit Court of County. Okay. Upper, lower case, proper grammar syntax. With respect to the entitlement of term, notice that those two words are capitalized because those are proper nouns. It is either general, probably supposed to be general. Thus, October term 1955 or special, right? General or special appearance. That is where a particular day or the term is stated. Such title refers to the time when, oh, okay, talking about the court itself, but it has to be in proper form. Okay. And look at this commencement, form, breach, damage, right? The form's got to have the right. What was the breach of the right? What are the damages of that right? Oh, how about that? There's the conclusions. What was the promise? I guess I don't know. Kind of hard to. I
Bueller.
might have to actually go to this one, but we're getting close to
Bueller.
the main part. where it talks about
Bueller.
the basic three elements. So the party is supposed to deliver his oral allegation in open court. See, I don't know where that took off from. Oh, wait, refers to the time. Such title refers to the time when the party is supposed to deliver his oral allegation. Oral allegation in open court. Oral. You have to give the oral allegation. That would be at the what? Initial appearance. Not arraignment, at an initial appearance.
And it's oral because these are called hearings, not seeings, right?
Right?
Exactly.
Yeah, Lady
Okay,
Justice
just
is
making sure.
blind, not deaf. So we have
Right,
to
right,
speak it.
right, exactly. Yes.
So,
Whoops.
let's see. And it was only in term time that the court anciently sat to hear the pleading. It is therefore
Oh
always
my.
of a term that the pleadings are entitled, though they are often in fact filed or delivered in vacation time. The term of which any pleading is entitled is usually that in which it is actually filed or delivered, or when this takes place in vacation. The title is of the term slash proceeding. When they're talking about vacation, is the court's out on vacation. The most frequent practice is to entitle generally, but it is to be observed that a pleading so entitled is by construction of the law presumed, unless proof be given to the contrary, to have been pleaded on the first day of the term, and the effect of this is that if a general title is used, it will sometime occasion an apparent objection. Thus, in the case of a declaration so entitled, it may appear in the declaration or in evidence on the trial that the cause of action arose after the first day of the term of which the declaration is entitled. And in either case, the objection would arise that the plaintiff would appear to have declared before his cause of action accrued, right? Or occurred. But accrued is because of damages.
Right.
So, whereas the cause of action ought, of course, always to exist at the time the action is commenced. The means of avoiding this difficulty is to entitle specially of the particular day in the term when the pleading was actually filed or delivered. That's why we have to have a certificate of service, or if you're going to do a summons and have it properly served, right? Process server, they have to write a certificate of service, an affidavit of service. And that's in anything. For probate court, for anything. Look it up. It's there. You got to fill that form out and send it back. And so, sometimes it's called an affidavit of service. Sometimes it's called a certificate of service, depending on what your particular state calls it. Idaho calls it a certificate of service. You're certifying that that I've sent this aforegoing mentioned motion, document, summons, whatever, and you have to name the entitled document, and you're certifying that you put it in the mail or send it through email, which is supposed to be acceptable on, the other side's got to give their consent to be served through email. Through the U.S. Postal Service, through FedEx, overnight, UPS, whatever. You're certifying that this is how you served them. Now, certain particular things, such as a summons and a complaint, have to be done through a process server. Unless you're talking about like in probate, you can have, it still needs to go through a process to be served, and that certificate of service has to be done, affidavit of service has to be done. But nonetheless, that's how you prove that you served. And you'll need that particular document for default judgments. Okay, so the objection would arise that the plaintiff would appear to have declared before. Okay, we know that. The laying of the venue was inextricably connected with the various stages of the development. I just saw it. Development of the jury. In the first stage, see, I tell you, this thing's broke up pretty bad.
Oh, man.
In the first stage, the jury was not a jury, but in reality, a group of witnesses who came into the court. And on the basis of their own knowledge of the facts, excuse me. Whoa. Knowledge of the facts of the specific case told the judge what happened. That would be at that initial appearance, wouldn't it? In order, therefore, that the juror or jurors with knowledge of the facts might be selected, it was necessary for the sheriff to know where they could be located. The rule at common law, therefore, was that every material and traversable allegation of fact in the body of the declaration, if affirmative in form, should be laid with a venue. Beside this venue, which, by the ancient practice, included the parish, town, hamlet, or as well as the county, there was another laid on the margin of the declaration and its commencement, stating merely the name of the county. So this is why it says in the Constitution that it's supposed to be filed where? In the county previously ascertained by law, because the law dictates where it's supposed to be filed, and that's part of that due diligence, due process of law, to be
Uh-huh.
proper, not have dirty hands, and make sure that you file the proper documents in the correct venue, locus jurisdiction, the location, territorial jurisdiction.
Uh-huh.
What county did the crime scene happen in? It was on the internet. What?
Yes,
Where is that?
that would be
It was
in
in
the
a
court of,
video. It was
in
in a
the court
video.
of,
See, right here's a video. See. Oh,
in,
good
in,
Lord.
you file that in the court of Facebook, right?
Right. Well, that would be a suit at stare decisis.
Right. Oh, God.
Should be laid with a venue besides the venue. Second stage of the development, the jury went partly on its own knowledge and partly on knowledge. What are we talking about? The jury here it would be a grand jury, wouldn't it?
Oh,
Because that's why they're going in and talking to the court, to the judge, say we're the grand jury here. The reasons upon which the original rule was founded gradually ceased to have any meaning. And as a result of the two statutes of 16 and 17, Car U, whatever, 1664, and of 4 and C 16 subsection 6, 1705, the rule requiring the laying of venue in the body of the pleading became an unmeaning form. Practice of alleging the venue in the margin. Hey, I bet that's supposed to be having been found sufficient for all practical purposes, but the practice continued to be observed nonetheless. Okay, so now we're still not even close. We're still on page. Oh yeah, okay, yeah, we're getting close. Page 85, which is page 86, is where we're really going to end up here, where I've read from before. Okay, in the meantime, the jury had reached its third state of development, in which jurors ceased to be witnesses and become triers of fact. Oh, imagine that. Going on knowledge furnished by the evidence heard in open court. With this development, an end was brought to the former practice of the rule of Hillary. Term 4, and no venue shall be stated in the body of the declaration. Yeah, it's not supposed to be in the body of the declaration unless you're talking about the who did what, where. The where dictates the proper venue. Where did the cause of action happen? Where was the crime scene? The where, out of that who, what, where, and when. However, in cases which require local description, the venue was still to be laid in the body of the declaration, right? But the enforcement of this rule did not call for the statement of a correct venue, except when the action was local. And in transitory actions, the venue could be laid in any county, subject to objection by the adverse party. Oh, you get to object to that kind of stuff? That personal jurisdiction? I'm personally not subject to this territorial jurisdiction. That would be that substantive due process that comes before due process of law. Can you actually prove that Field McConnell was in Broward County, Florida at the time that you're claiming this right to a cause of action? Because if you can't, tisk, tisk, tisk. It comprises the parties correctly named. The body of the declaration is the most important part of it. For it is here that the plaintiff states the facts showing his cause of action. You have to put your cards on the table. There you go. Here's my statements of facts. I'm alleging that these are the truth, right? And that I have evidence to support these claims, these facts, because the truth can't become fact without evidence. So, just because somebody says something, well, this happened over here. Yeah. Where's the evidence to support that claim? Yeah. That's a tough one, ain't it? They don't think they have to supply any evidence, but they do. At
You
least
mean
with
they
me, they
actually
will.
have to show where somebody actually did cause injury or harm?
Right. Some basic elements of a right to a cause of action is
I would think so. Now,
part of
I
the
mean,
body from the rules of the common law.
right, right.
In the declaration, the part of the body part of the declaration, you have to put it in there. Oh, wait, there it is. Huh. Important part of it states the facts showing the cause of action. But what is a cause of action? Gould defined a cause of action as a set of facts which entitles the plaintiff to the relief claimed. Failure to state a claim for which relief can be granted.
There you go.
Because, see, judges don't have the power to order the people around.
Nope.
You have to claim your right to a cause of action, prove your right to a cause of action by declaring the causes. But on analysis, the pleader will find that the facts prescribed by the substantive law as necessary to constitute a cause of action in a given case may be classified under three heads. Here it is. This is the one. The plaintiff's right or title, the defendant's wrongful act violating that right or titles. And when we're talking about title is a contract. You're entitled to specific performance under the contract and they failed to perform. So you're entitled, you have a title. Okay. Number three, there it is, the consequent damage, whether nominal or substantial. And of course, the facts constituting the cause of action should be stated with certainty and precision and in their natural order, so as to disclose the three elements essential to every cause of action, to wit, the right, the wrongful act, and the damages. I arrest my cases against the shit made up out of Broward County, Florida, and all the cohorts, all the conspirators that have conspired with her. That's a felony, by the way, and that's actually a capital offense in accordance with Title 18, subsection 241 and 242, and especially if it involves kidnapping. we can seek the death penalty because that's what the law says. I didn't write it, but that's what it says as it is written. It is a capital offense like murder, kidnapping, rape. Those all three of those are actually capital offenses because you have defiled life. You deprived someone of their life. Yeah, treason is a capital offense. So, the conclusion of the declaration is the formal statement at the end following the CVP and no. Here we come. Body or statement of the cause of action. It is to the plaintiff's damage of, and therefore he brings his suit, etc. This, so demand for relief. Add dam num num num. Guess I don't see where that's. Damn num. Clause is properly a part of the conclusion in all personal and mixed actions by the Common Law Procedure Act of 1852. Wait, 1852? Isn't that after 1776?
You'd think once or twice.
After 1787?
Yeah.
After 1791?
Carry the two. Let's see.
Okay.
So,
So, in 1852,
oh,
the
Lord.
specific form of conclusion was prescribed. And again, technically speaking, the legislature does not have the power to alter the fundamental law.
Nope.
So, the production of the plaintiff's suit, secta, by which the plaintiff was required to present proof of his declaration at once, prove that you served it on the defendant. That would be proper service, notice in the private. Ooh.
When they altered the fundamental government in 1996, that kind of rises to the level of the Virginia causes and necessities for taking up arms. Remember,
Yes,
we've
sir,
read
indeed.
that once or
Yeah.
we've read that once or twice on this show, have we not?
Yes, we
Right.
have.
So when you're declaring causes of action, right? One such example of a declaration of a cause is that document that we've shown, right? That's the history behind the signification of the name of that document, right? So
That's right, Stephanie. This is the common law, the law that is common to all. This is the common sense law. Back in the day, everybody knew this.
Right.
Everybody knew this.
Correct.
Because they were taught it in school.
Oh, yeah.
At the church.
Yeah, the schoolhouse that used to be the church house that used to be the, right?
Church on Sundays, schools Monday through Friday.
Something like that.
Schoolhouse during the week and church on Sundays.
Hence the schoolhouse rock, how that came about, right?
Right.
Speaking of succession of law,
So let's see. By which the plaintiff required present proof of his declaration at once and even before it was called into question upon the pleading. Right. Before it was called into question upon the pleading.
Right.
Is an example of one of those instances not infrequently noticeable in the common law pleading, where the form of an old procedure is retained long after the reason for its existence has been swept away. Anciently, in the primitive period of common law procedure, when pleadings were still made orally and trial by battle or ordeal, we used to do that, dueling. You used to be able to say, you know what, screw this. We're going to settle this by dueling. We're going to battle it or ordeal. Literally took to the streets and, somebody sometimes got shot. But see, that's where, in my mind, where the conscience would kick in. And, if you knew you were wrong, you couldn't in good conscience pull the trigger. Or if you did pull the trigger, and I've read this before, that the people in good conscience that knew that they were wrong, they had dirty hands, would actually fire to the ground or off to the side or up in the air off to the side and never directly at him, which is Alexander Hamilton's mistake, because he actually thought the guy would not shoot him, and sure as shit, he did. But anywho, this is it. This is where we're going to get into right where it says here at common law, according to Martin, the signature of counsel was not required, and this rule was enacted into statutory form by the Common Law Procedure Act of 1852. The actual statement of the cause of action. Here it is, number 21. This is the page that I read from right out of this book. I've showed it on the show. This is it. Again, laying it out. The declaration must state distinctly and with certainty every fact that is essential to the plaintiff's prima facie case on its face, on the face of the complaint. No essential allegations can be imported, as in brought into question or as used evidence, into the declaration by inference or intendment. Well, I intended it to be there, and well, it kind of does say this. No, it either does or it does not. In other words, if it's not proper in the declaration, you lose. You can't say, well, it kind of does say that, or, well, I intended it to say, sorry, but it doesn't. That's not sui juris. You're not being perfectly capable of handling your administrative duties. If you can't articulate what right was violated, what was the conduct that violated that right, the who, what, where, and when, and what the damages are. What did it break your leg? Did it hurt your toe? Did you hit your thumb with the hammer? And whose fault is that?
Right.
The principal points to be shown in any statement, shown in the statement of a cause of action are, again, number one, the plaintiff's right. Number two, the defendant's wrongful act violating that right. And number three, the consequent damages. Right there. I mean, this is fundamental, basic, common sense. If those three elements are not in a complaint, the complaint is not proper before the court. It's not in proper format, and it's deficient in stating what the plaintiff's right was or what the defendant's conduct was that violated the right. Or number three, failed to state the damages. Well, he erected my fence. I want my whole house painted, and I want
Right.
the water main fixed and the fence fixed. No, failure to state a claim for which relief can be granted. The
Yeah.
jury can't grant that relief to the plaintiff. That's absurd. It's beyond the scope of the fence.
Right.
So, there you have it, folks. I mean, I don't know. So in the PDF, page 97 of 735. Now, this is why reading means reading.
There we go again.
So there it is, folks. That's that right to a cause of action pursuant to the Fourth Amendment.
Right.
No warrant shall issue.
Well, and again, so
without a cause of action.
Right.
Properly laid before the court. Because you're
to.
That's fraud upon the court, right? When you're inducing the court to take action against another man, when your shit ain't even fucking proper before the court.
And if they think it is, right, and you can show them that it is not, right, we have principal practice for that, right? One of the questions on Facebook was specifically related to guardians ad litem, okay? You're
Okay,
questioning
go.
their standing, right? This is the Latin principle for questioning standing, right? The person whose legal position is an issue. Who is this jackwagon and what the hell are they doing in this room, right? So, fundamentally and principally, right, from the language of law, Latin, okay, this is how they enter, right? Ad Nintendo, which kind of like, you know, makes my brain go to, Cartman, where is the Nintendo? No, 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 no. This is not Nintendo. It's Admitendo. How you want to kick their asses out of the room is de custodi amovendo, right? Get the hell out of here. That's basically the short version of that. So, this is, and of course, when you file this stuff, you file it, and you know, my granddad always used to have a saying: "Paper's cheap, man." So, what you do is when you file, right? You don't just file into the judicial branch, you file also into the legislative branch, and you serve a copy to the executive branch, right? So, this is where you are claiming, exercising, and managing the emoluments of your government. You certainly have standing to do this, right? So, this is right. Remember, we said it's a fundamental principle, it's a maxim. Everyone is the manager and disposer of his own matters. So, if it's one thing to go in there and say, okay, yeah, I can do this. Well, okay, well, did you do it? And what principle did you know, what's your cause, right? you know, um, what mechanism in law are we talking about? So I said, okay, I'm just going to swallow a legal dictionary and brush up on my Latin, the language of law, right? And I'm going to go in there and I'm just going to smack the crap out of these guys because, hey, while I was at work, right, performing my craft and the various duties under the emoluments of my office, some jackwagon came in here and claimed they had a right to alter the fundamental law. No, you don't, right? So this is why when you serve this to the legislature, right? And of course, I'm nothing if not patient, right? We already know those foreign emoluments, that corporate state, right? That Islamic corporate state has no standing. That's kind of the point of impeaching the law the way we did. So, you take that case, right? And do you remember that fake impeachment sham shit show that went on, right? Well, there were two federal cases that the Democrats also filed, and both of which were summarily dismissed due to lack of standing, basically with prejudice. In other words, aha, you don't even have a right to a cause of action here, dude, right? So, um, whether he's in his personal or in his official capacity, right? We've shown that on, I showed the decision there. Matter of fact, I can pull that back up again just because, for clarification purposes, we like to make sure we do that. And that would be, I think it's this one. Monuments Clause opinion. This thing was only like 6 pages. Yeah, here it is. Found it. All right. Because the claims, let me see if I can zoom in on this, make it easier for you guys to read it. All right. Because the claims that the district and Maryland assert against the president in his individual capacity are identical to the claims they assert against him in his official capacity and are premised on the same factual allegations. Our decision and appeal, number 18-2486, also decided today and addressing the same standing issues or same standing issue, right? Standing in law governs the outcome here. We therefore hold that the district and Maryland do not have standing under Article 3 to pursue their claims against the president in any capacity, including his individual capacity. No standing, right? I'd rip the freaking rug right out from underneath their asses. That's why I said you want to play Monopoly Corporation with loss prevention and you think this is going to work out well for you? Wrong answer. Accordingly, based on this opinion and our opinion in number 18 2486, we remand with instructions to dismiss the complaint with prejudice. There it is, right? This Sharia law state has no standing. You want to know how to go in there and beat their ass with it? Merry Christmas. So, uh, Democrats' shitter was full or something. I don't know. I'm just making this up as I go, so bear with me. But they also cite the process, right? And I'm going to share that from the other screen because I've got multiple screens going here. And when you bring this to the legislature, remember that was this page 25, section 16, right? Well, we already know fraud or bad faith will invalidate acts in the legislature. So, because these jackwagons have no standing, right? Again, you can include that case I just showed you right along with these cases down here, their starry eyed deceases they love so much, which is basically saying, I don't have to go to the court to ask the court this question. That's already been done, right? So, again, I am here to agree with this judge that these jackwagons have no standing, and here's why, right? So that's where we get into the, fraud versus bad faith, right? And because we already know fundamentally and principally that Title IV at all, the entire thing, matter of fact, I'm going to show the design matrix, right, of that. We're going to play matrix here. Um, Again, I want to say thank you to the Obamacare team on this one. These guys kicked ass. So we did the analysis, or they did the analysis on the whole Obamacare mechanism, right? This is the same thing as Title IV. The only difference is it's the the financials are a lot different than Title IV. Okay, but the model's the same. Still advantages, profits, gains, and of course these benefits packages, right? These benefits packages from the whatever. But the the whole point is this jurisdiction foreign to our form of government and unacknowledged by our constitution, beginning with the fourth pillar, right? Well, our color of law is advantage, profit, and gain. Benefits are not even they're not even there, right? Benefits are something that you purchase, right? So when we went through and they, put forth the analytics on this, okay, that's why I said this was fundamentally and principally, to me, it was fishing in a bucket because part of my job was to assess design matrices of business plans, just like this. So because this business plan fundamentally altered the law, well, this this mechanism, which in Title IV was passed in 96, that doesn't have a darn thing to do with my ex or my kids. Get the hell out of here. So, you know, you want to know why I keep kicking the crap out of these jack wagons? It's because it's like, okay, remember, I still get the same deer in the headlights look you guys get.
I
What do
know,
you
right?
mean, Sharia law? Oh, God. You know, to me, to you and me and Kirk and those of us who have been watching the show and been doing this for a while, it's one of those truths we hold to be self-evident, right? But knowing and understanding that these people that are sitting in those emoluments now, we're just bringing them up to speed, right? So, you know, dude, I'm sorry you were told that this was going to be your job, but your job is not actually what you were told. I hate to be the bearer of bad news, and I know this is going to suck, right? For you, because this is not what you thought you were getting yourself into. Well, again, this is the how many jobs have you ever taken in your life where, okay, I'm going to do this job and it's going to be all glorious just when you get there and you go, this sucks, right? So that's why it was, that's the book, dude. This is Republic for Dummies, man,
That's
right?
it.
So, yeah, that's it right there.
Gotta have it. That's the guidebook for dummies for the legislature.
That's right. So, I mean, if you
Legislative
don't,
procedure,
yeah, the
rules of
manual of
procedure.
legislative procedure, right? So,
If you want to redress your grievances or you want to take any kind of action in the legislature, you want to get politically active,
mhm,
well,
yeah, just
don't you
know
have
the
to know the rules
process.
of procedure? I mean, you got criminal rules of procedures, you got civil
Hmm.
rules of procedure, we got,
Well,
probate.
how
The
about you got a case, you got somebody out there saying laying a false claim that they have some kind of equitable interest in your real property? No, you don't. Where the hell did you come up with some kind of crazy notion like that? Can you prove that? Right? You know, there's nothing to do with the Constitution at this point. Show me in the transaction, bro. Show me in the transaction where you have that equitable interest, and show me where you disclose that to me where I signed it. That's yeah, that's what you can expect every single time. But if you don't take that grievance to the legislature by the time and say, "Oh, by the way, um, we don't know," you know, depends on your locale. Now, I know Commonwealth states are different from, the actual, the Republican states and that kind of thing. So, I mean, again, there's some variations to the process in there. I always tell everybody the exact same thing. Go to your legislative website, right? Find out number one, which book, right? Are you using Reed's? Are you using Masons? Are you using um, Roberts, right? Are you using Jefferson's? I mean, there's the four. So, but this is, one of the main reasons why doing this way establishes your claim and overcomes that motion, that 12B motion to dismiss for failure to state a claim for which relief can be granted, right? So
See those right there? There's my Idaho
there
Senate
they are.
rules of procedure, House rules, and them damn joint rules.
Want in on this, man?
Bongs, was it bongs and pipes to the left, joints to the right?
Right, right.
No, right. I remember back in the day, I was like, "What do you mean joint rules? What the hell are
Right.
you talking about?" Well, rules of procedure. Oh shit.
Yeah.
Well, here we go. Now this is how I found mine. Watch this. Everybody, no, I guess not everybody knows this because I didn't know this until somebody's
Right.
like, "Hey, Control F." Okay, Control F brings up the find box. Guess what? I'm gonna type in manual. There it is. Rule 75. Standard rules. The rules of parliamentary practice set forth in the Mason's Manual of Legislative Procedures shall, remember the word shall?
Uh-huh.
Uh-huh. Shall govern the House in all cases to which they are applicable. What? Wait, the legislature handles cases? Yeah, it's the
I
court of justice, folks.
ding 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 where you
The
protect your
courts of law and
liberty
courts of
interest.
equity are in the judicial branch.
Right. So
Courts of justice are in the legislature,
that's
which is
right.
why we keep telling people that the law says, what does the law say? What does the law say? How about we start with The reason why we instituted government, that's the preamble.
Yeah, there you go.
We, the people of the state of Idaho. Notice it says lowercase s there.
Your
That's
intent
in
for doing? Yeah, sure.
proper format, proper form, right? And what about the people of the state of Idaho? We're grateful to Almighty God for our rights, our freedom. And what? To secure its blessings, God's freedom, natural rights, and promote our common welfare, do establish this Constitution. We establish, institute government. There it is. Law is that which is laid down, ordained, or established. This Constitution is established, laying down the law. What
Dope.
parts of the law are we laying down here? Declaration of Rights, right? American Jurisprudence, Volume 16, Constitutional Law, Section 100, Bills of Rights and those merely declaratory of the common law,
Hmm.
your rights as the law, all be darned. This is the law of the state. And
Dope.
what does it say as it is written? When you read it, what does it say? It says, as it is written, the political power inherent in the people. All political power is inherent in the people. What is it?
Row.
Government is instituted for their equal protection and benefit. This is the law.
There it is.
And they have the right to alter, reform, or abolish the same whenever they may deem it necessary.
Hmm.
Now, pay
So,
attention, folks. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. This is why we have to go to the legislature to remove their privileges and immunities from being sued.
exactly.
Yes, I know about ultra vires, Owens versus City of Independence. Yes, I know all about that.
It's all in the
But this
document.
is the process.
Hmm.
The law dictates
Right.
process that is due to these public servants
So,
because that's what a remonstrance is about.
that's right.
But
So,
let's look
again,
more at the law as it is written. Section 10, right of assembly. The people shall have the right to assemble in a peaceable manner. And what that means is that we have the right to call the House and Senate into assembly. Why would we have that right?
dope.
Well, so that we can consult for our common good, to instruct our representatives. Oh, we have that power. We have that right
Oh, you
because
mean
that's
that?
the law that dictates that all power is inherent in the people,
Yeah. So
not
that starts
government.
on page 551 in the book, right? So that's that part 9, sessions and meetings, chapter
Right.
72, sessions of state legislatures, right?
Right.
So,
So
you know,
let's continue here. It says, and to petition the legislature for the redress of grievances. Because that's what it says. That's how our rights work as the law.
mhm.
We have a duty to follow this law because this is the actual law, not statutes, codes, rules, procedures, regulations, and city ordinances. This is the law of the territory of Idaho. Now, we'll go up here. Guess what? Let's do petition. Uh-oh, what does that say? Rule 12 of the House, petitions, memorials, remonstrances under etc. Petitions, memorials, and other papers addressed to the House shall be presented by the Speaker. Okay, well, this rule is in direct conflict with the right. See, rules are not law. Because We have the right to present our own petitions. But then, though, let's look some more. What does he say? Let's go back up. Rule 60, order of business. So they're doing business, are they? That's right, they sure are. After calling the House to order, the order of business for the day. Look at that, folks.
Oh,
The order of business for the day shall be as follows. The roll call. Look, they even have to have prayer by the chaplain, followed by the Pledge of Allegiance every day. Approval of the journal is the transcripts from the previous cases, hearings. Okay. Consideration of messages from the governor and the Senate, report of standing committees, report of select committees, motions, memorials, and resolutions. Introduction, first reading and reference of bills and joint resolutions. This is where John Gentry went in, and the guy's like, well, reading doesn't mean reading. No, it does, because it's on the order of the business for the day.
Whew.
Get to reading.
You're right.
First reading of engrossed bills, second reading of bills and joint resolutions, third reading of bills and joint resolutions. That's right, because they're supposed to read this stuff on the record in open court of justice 3 times. The law requires that.
That's right. And that doesn't mean joint, doesn't mean puff, puff, pass. Just
Right.
saying.
Consideration of
Just
general
saying.
orders, miscellaneous unfinished business. And then once they get done with their official type business for the day, what's the next thing on the order of business for the day? Presentation of petitions and communications. Do you see why it says without delay? When you file your petition of grievance or remonstrance, it is supposed to go on the order of business for the day. It is to be read the day that it is served.
Right.
Now, in my rules, it says anything after 10 a.m. must be put on the order of business for the next day. This is without sale, denial, or delay.
Right.
That would be 17. Oops, 18. Right? This is back to that basic Magna Carta due process that I've showed before, which I'll bring it up here again in just a second. Justice to be freely and speedily administered. Courts of justice, which is in the legislature, not the judicial. This is a political argument, not a judicial one. This is dealing with domestic violence, because domestic violence is internal insurrection. Bad actors in government in the form of a remonstrance. So, shall be open to every person, and a speedy remedy afforded for every injury of person, property, or character. And right and justice shall be administered without what? Sale, denial, delay, or prejudice. File your remonstrance and demand that it be put on the order of the business of the day. Bring up these rules and show them and instruct them that to perform their specific duty under their emolument, or you're fired. But the reality here is, again, we've all been taught wrong. These people, in Idaho, it's never been exercised, not once,
right?
Since 1863.
Dope.
People been derelict in some duties. See, look at that.
Throwing them their potatoes.
I want you to put this in your mind right here. Without sale, denial, delay, or prejudice. Most important, without sale, denial, or delay, because that comes from the Sixth Amendment. Oh, wait, that's also part of, wait, that would be, Sixth Amendment. Or is that, is it the Fifth?
No, Fifth is to be, you don't have to incriminate yourself.
Or should held for capital or otherwise, here we go, infamous crime. But it is what I want to bring. I'm going to come back to that.
Fourth
because
Amendment, I think, is what
this is where we schooled age at 19 in the Zoom, which he failed to put out in his video, where he got schooled on the law. Not us, him. So the Sixth Amendment, I'm going to go into the C explanation because this is that sale without sale, denial, or delay that I'm talking about. Your right to a speedy and public trial. Source and rationale, that logic and reason again.
How dare you
Oh,
bring
look at
up
this.
logic and reason? Damn
When
it.
Magna Carta declared, laid down the law.
Ruh-roh.
We shall not deny or delay justice and right, neither the end which is justice nor the mean whereby we may attain to the end, and that is the law. You cannot deny or delay justice and rights.
Nope.
And it used to say, to no man will we sell, to no man will we deny or delay justice or right. That's section 40.
Well,
Because that's what
again,
it says.
as it's written.
Oh my gosh, look at that. Portion of chapter 29 of the 1225 reissue. So we got 1215 and the reissue of 1225. Translated and quoted by Edward Coke, the second part of the Institutes of Laws of England, Garland, 1979 facsimile of 1642 edition. See also Cloffer versus North Carolina, 386 U.S. 213. The Cloffer court cites an even earlier reference to the right to speedy trial, dating from what? 1166. That's the Aziz of Clarendon.
Dope.
These rights have been around for a very, very, very long time.
1 or 2 years.
Which is why in the Declaration of Independence it says that these rights are self-evident.
Right.
Because by 1776, it should be self-evident.
You'd think. You know.
I mean,
holy crap.
It is in writing. The Bill of Rights is in writing.
Yeah, on the record.
Published.
And it's on the record.
And see, this is where I get into that succession of law, because we're talking about the Magna Carta here.
Right.
Much of the same language was incorporated into the Virginia Declarations of Rights of 1776.
Uh-huh.
Why are they citing the Virginia Declaration of Rights of 1776?
Therein lies a good question, does it not?
Because that in itself is the law, laying down the law of this nation.
Mm-hmm.
In history, nations are not created every day.
Right.
But this document is the one right out of Annals of America, Volume 2, looking up the Virginia Declaration of Rights, as the theoretical foundation of all government. And that's because at the time that this Virginia Declaration of Rights was written, was when we were separating from Great Britain and laying down the law of the nation called America. We were establishing the nation. We were declaring the law of this nation. This is part of that
right.
fundamental law, the organic law, the law of creation of the nation called America.
Right.
And there's, people seem to think it's the Declaration of Independence.
Nope.
Wrong. You've been lied to. The first document would be all the way back to the first charter of Virginia in 1606, which was before the Mayflower in 1620, because Jamestown, Virginia, was established in 1603.
Mm-hmm.
And this all goes into the Virginia Plan, and most all of the states, colonies, were born out of Virginia and was all in the territory of Virginia.
Right.
At this time. Okay? They were not sovereign independent states yet. So this is where you have to comprehend laying down the law before instituting government. So we'll start with in the First Continental Congress, when they started to assemble to redress their grievances. That would be what, July 6th, 1775,
Actually, in early May of
with the
1774, the Boston Committee of Correspondence sent
right.
a
No, I've been talking
circular
about
letter.
that one document we were talking about before. The
Oh, right,
Declaration for the Causes and Necessities for Taking Up Arms,
right, exactly,
July 6th,
exactly.
1775.
Hmm.
Okay. Why did they take up arms? Because of tyranny, for interdicting all commerce onto the people, easy
Right,
emoluments of statutable plunder,
right.
for extending admiralty jurisdiction beyond its ancient limits,
Well, and
for bills
again,
of attainder, pretended acts of legislation. In 1775, they were
mhm.
declaring this. Okay.
Well, and I'll tell you what. Let me.
Well,
Speaking of history,
I want to
you want
finish
to.
these documents real quick. So,
Well, okay. Well, go. I was going to say because if you want, I can do a real quick history on this because it makes for a very interesting conversation when you're going to be talking to a legislator, right? You're
mhm,
saying, by the way, do you guys even know the history of Congress? Right?
right,
Do
right.
you really even know what the original Congress was designed to do and why businesses incorporate into the legislature?
Hmm.
Right? Because it was basically dominated by the original Continental Congress was of 51, dominated by merchants, right? That collectively, right, decided to um, contribute, not through taxation, right? They built these armories, stores of weapons and ammunition, right? That was their contributions, right, to fending off a potential foreign attack, foreign emoluments, right? So, and when you go into and you start basically, you state something to the effect of kind of one of the purposes behind this thing, right, was to deal with something known as a let's see here. Wait a minute, wrong. Here it was. The Tea Act. Remember the Tea Act, the Boston Tea Party, right? The thing that it the reason for the Boston Tea Party. I'll just go ahead and put this up on the screen, right? Rumors were planted to the effect that the Tea Act created an illegal monopoly, right? We've been fighting foreign monopolies since the first Continental Congress. I lay money, probably one out of every 500 legislators even knows that. Well, I guess if they're watching the show, they would certainly know it now. But the point is even bar members aren't taught this stuff. They're not taught this in law school. This is
Right,
American history, right?
right.
So when we go in and we basically state that as one of the people, I don't need a foreign emolument to go in and handle my business, right? I am a craftsman corporation, right? I'm incorporated here, buddy. I have a grievance. So, again, why does that give me greater standing than you? I don't think it should, right? And if you agree with that assessment, by all means, go tell them that you agree with me on that, right? Because that is the, basic fundamental principle. And no, nobody had the right to alter the fundamental law way before they even sat in the chair. So whatever business they were doing back then, we don't give a damn. We're here to undo it.
Yep.
So,
So, we'll go back to what I was talking about. There's the fact that these documents is what
mhm,
institutes the law of the
mhm,
nation itself.
right.
So this is why the Virginia Declaration of Rights is referenced here in what's called succession of law, our rights as the law. You can't skip over these documents because these particular documents are in history, as it says right there. F. Thorpe, the Federal and State Constitution, House Doc number 357, 59th Congress, Second Session, something 3813, and this was in 1909 that they went through this.
Yeah.
That's right. I mean, 1909 is not too long ago in comparison to 1776, right?
You would think.
So why is it here? Why is it? This is in the annotated Constitution. This is like the holy grail of the Constitution when it comes to court findings of facts and conclusions of law.
Right.
Is the annotated Constitution. Has
That's
already
right.
been discussed.
Right.
And this is why they're saying this is the source and logic behind why we have the right to a speedy trial, why we have the right to a trial by jury, why we have these rights that we have, because it was discussed right here. So there's no denying the truth, facts, and evidence in the record, on the record, right here. It's already been to court.
That's right.
From there into the Sixth Amendment, right to a speedy trial is a right of an accused, but it serves the interest of defendants and society alike. The provision is an important safeguard to prevent, here we go, undue and oppressive incarceration prior to trial. To minimize anxiety and concern accompanying public accusation and to limit the possibility that long delay will impair the ability of an accused to defend himself. What do you think's going on with Field McConnell? Where are you guys at on his right to a speedy trial?
There you go.
You're running out of time.
Running? Shit, they were out of time.
Well, the day that he got arrested, you got 6 months.
Bullshit.
Mandatory minimum,
90 days.
or maximum, 180 days. Some states have it down to 120 days right to a speedy trial by a jury of your peers.
Just saying. If you can't put a case together in 120 days, then you shouldn't be doing this job. You should be flipping burgers for the damn clown.
But this is and to quote, an important safeguard to prevent undue and oppressive incarceration prior to trial, to minimize anxiety and concern accompanying public accusation, and to limit the possibility that long delay will impair the ability of an accused to defend himself, end quote. Because that's the reason why we have that right to a speedy trial.
Mm-hmm.
So the people are not incarcerated forever.
Right.
And to minimize anxiety and concern accompanying public accusation, and to limit the possibility that long delay will impair the ability of an accused to defend himself. Okay, so we're talking some psychological things going on here as part of the grounds for having a right to a speedy trial. Imagine that. And what's going on right now? Public accusations against Field, even us. The people that were supposedly on the same side, same team, are now out there trying to bash us.
Right.
Clearly, they don't know what they're talking about.
No, they don't know shit. They wouldn't know their ass. They wouldn't know their ass from an emolument.
And then look at this. But on the other hand, so they're playing devil's advocate here. There is a societal interest in providing a speedy trial which exists separate from and at times in opposition to the interest of the accused. Imagine that. Persons in jail must be supported at considerable public expense, and often families must be assisted as well. Why do you think we talk about judicial estoppels? Why do you think we talk about extortion violations under the Hobbs Act?
There you go.
Why do we think we would talk about emoluments violations?
There's the word. Right.
That's
so
it right there. Getting paid, using your position of employment or holding office as an advantage to do this to Field McConnell.
Right. So
To do this to
basically,
Tim, to do this to me, to do this to everybody else that they've been doing it to for years.
right. So if they're using and they're withholding exculpatory evidence, which is what was obviously present, in my particular case. I don't know about you guys, but when I went in and said, oh, well, that's an emoluments violation under Brady, that was the proper way to speak the law, right?
Right.
And this is where they're screwed. So
So
this is
here's
why they constantly, are trying to disparage us,
mhm.
right?
Deny and disparage.
Right. So, yeah.
So persons free in the community after arrest may commit other crimes, right? So we want to make sure that we get them prosecuted timely. So lengthy intervals between arrest and trial may promote bail jumping. Right. That's why we have a mandatory maximum time of 180 days. It may be less in your state, but it's a federally mandated minimum or maximum of 180 days. Right to a speedy trial cannot supersede 100. I've actually had, there's another one. One of my cases dismissed for violation of a right to due process of law. My right to a speedy trial was violated. Well, of course, they kept putting it off because they kept up making excuses.
Yeah, they
Because,
couldn't get you to
of
suck it
course,
up and fatigue you into compliance with their measures, you mean?
this is the next part. And growing backlogs of cases may motivate plea bargaining that does not
Oh,
always match society's expectations for justice. They wanted to plea bargain, and I said, no, I'm not guilty. You're going to have to, we're going to a trial by jury. And they knew that they weren't going to prevail at a trial by jury. So they kept making up excuses for continuances. And on the third continuance, well, when we came back to court for the third continuances, motion for dismissal for violation of a right to speedy trial, the judge says, hereby granted. We can even hardly finish the sentence of why we wanted it dismissed, and it got dismissed. Imagine that. So that jack wagon that was out here on Friday night, there's another $500 you owe me.
yeah.
That's a win, ain't it?
I'd call
Every
that a
case
win.
dismissed for violation of your right to a speedy trial, still a win.
Still an emoluments violation, right?
That's right.
All right, just
So,
saying.
and delay may retard the deterrent and rehabilitative effects of the criminal law. Imagine that. So that footnote 14, chapter 40 of the 1250 matter, a portion of the 12 of the 29 of the 1225 reissue, translated and quoted by Edward Coke, the second part of the Institutes of Laws of England, if you'd like to look that up. I highly recommend reading Cloffer versus North Carolina. I have. The Cloffer court cites an even earlier reference to the right to a speedy trial dating from 1166, which goes clear back to the Aziz of Clarendon.
Mm-hmm.
And yeah, notice even at 15 and 16, they're still citing that Cloffer versus North Carolina.
There it is.
Okay, I mean, this has been discussed and discussed and discussed, and they know it. The
That's
Speedy
right.
Trial Act of 1974. Well, I'm sorry, if our right to a speedy trial goes all the way back to 1166, I don't think we need a congressional act on our right. Thank you very much.
Exactly.
You don't
Exactly.
have subject matter jurisdiction over our rights.
Yeah, quit trying that shit.
Nowhere in the Constitution was that power delegated.
Well,
That would
actually,
be
it
a
was. We have the right.
democracy
Yeah,
where they
the
put your rights
power.
to a vote.
Yeah, the power is delegated. It's delegated to the people, right? As your right to a
Yeah.
speedy trial. Why do we need legislation on that?
Now, what does it say? What does it say? Codified the law. Wait a minute. I thought congressional acts were law. Wait, it says public law. Oh shit. Wait a minute. What do you mean you're talking about codifying the law with respect to the right, intending to give effect to the Sixth Amendment right to a speedy trial? So the intent to codify the law.
It's attempting to interdict all commerce onto the people, is what it sounds like to me.
Well, they were trying to give effect to the the fact that we have the right to a speedy trial, 180 days. So, but the fact is even then, it's not law.
Well, again, I don't need a SKU
It's a
number to tell me
codification
that.
of the law.
Yeah.
So why not just read the law?
Isn't that what I just said? Why do I need a congressional act?
I'm
Yeah. Yeah.
come on. My
Maybe you're
brain's
not.
just like working overtime here. Why
Yeah.
not just read the frickin' law? We don't
Wait,
need the Speedy Trial Act of 1974.
you mean that would be a repugnant act, right? Yeah. There's a
A
lot of
repugnant act
repugnancy
cannot be
going
brought
on.
into being.
Yeah. So,
But
but
see,
that sounds a lot like the codification sounds a lot like interdicting all commerce onto the people. And the reason I say that is because I know one or two things about code, which you guys are going to learn as soon as I get this damn PowerPoint done. Because
right,
I'm going to show you some stuff about code. You're going to be, huh?
right.
So,
And right out here on YouTube, trick us out of a speedy trial. Frickin' bastards.
yep.
Yes, that's exactly it right there.
Confidence
To
scheme,
trick
confidence
us.
game,
Confidence
confidence
trickery.
trickery. Ding, 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 ding.
Subjecting us to pretended acts of legislation. Well, we made law. No, you didn't.
You can't make law. Who the hell
You
told
don't.
you your job was to make law?
Congress shall make no law respecting any of our rights, is what that actually means in the First Amendment.
Well, let's talk about the First Amendment because what is Title IV? If it's Sharia law, what is Congress shall make no law with respect to religion? Specifically says it.
Yep. Let's see. Let's see what it has to say. Now wait. If according to the preamble here, right? Let's look at this. Let's use some logic and reason.
No other nonsense or shit made up. We're just going right back to logic and reason here, right? Okay.
Right. So we the people of the state of Idaho grateful to Almighty God for our freedom to secure its blessings and promote our common welfare to establish this Constitution. So we're grateful to Almighty God for our freedom, our
Mm-hmm.
rights. And to
Right.
secure those rights, governments are instituted among men, receiving their just powers under the consent of the governed. That sound familiar? That would be the Declaration of Independence. So, when we look at this First Amendment, where it says Congress shall make no law, we're actually talking about natural rights and civil rights that have nothing to do with the establishment, support, or management of government. That's not what we instituted government for. You don't have subject matter jurisdiction over natural rights and civil rights.
That's right.
That is a republic where we go by the rule of law, the common law, the law that's common to all. Okay. This is why we don't go by the congressional acts rule of man.
Right.
We go by rule of law.
Because when the laws of man fail, the laws of nature must be used. It's a maximum or fundamental principle of law.
So, knowing this, why does it say respecting the establishment of a religion? Because one, the Virginia Declaration of Rights lays down as the theoretical foundation of all government in this nation called America, that Christianity is our ideology. It's where our morals and principles and the fundamental law comes from, the law of the nation, because that's how a nation is created. And again, it's not every day that a nation gets created. So not many people know the law behind creating a nation, the law of creation. And this is why I ask the question once in a while to certain people is, well, is there any law that's higher than the Constitution? And sometimes I get that deer in the headlights look, and they're like, huh? What do you mean there's law higher than the Constitution? Well, yeah, first of all, what about all the law that the government was instituted to secure the blessings of those rights, that law? And then what about the law of the nation? The law of the nation came before the Constitution. Again, Constitution institutes government. Got to lay
Uh-huh.
down the law of the nation prior to instituting government. That's just how it works and has worked for a very long time. Since 1166, at least.
Ish.
And actually, we'll go further back than that. But let's see. Well, let's start right there at the top. An overview. Let's look at Madison's original proposal for a Bill of Rights provisions concerning religion read, "The civil rights of none shall be abridged on the account of religious belief or worship." So, in other words, you didn't have to go to church. You didn't even have to believe in God or worship. And you still had these rights. Why? Nor shall any national religion be established. Why? Because the Virginia Declaration of Rights declares the law of this nation, religion of this nation. And Congress doesn't have that power.
Hence the First Amendment.
Congress was instituted to protect and secure that law. Nor shall the full and equal rights of conscience be in any manner or any pretense infringed. There's that word infringe again.
Ruh-roh.
Imagine that. Why? Because that falls right in line with what? Natural rights and civil rights have nothing to do with the establishment, support, or management of government.
Nope.
American Jurisprudence, Volume 15, Civil Rights, Section 2. And notice that it talks about the equal rights of conscience, our own constitution, our own internal dictates of the mind. And in fact, the Virginia Declaration of Rights even says that right there. Okay, this is why we have the right of self-determination and why public law is policy and it has absolutely no force and effect as law on the people, except those who by contract for a what? A stipend, which is elected or appointed in a position of public trust, or a subsidy under a contract of employment. Imagine that, how our form of government goes by the rule of law, not the rule of man. But the language was altered in the House to read, "Congress shall make no law establishing religion, or to prevent the free exercise thereof, or to infringe the rights of conscience." Oh, no. Just so people know, I have personally been asked this question in court, and do you think, because you have the right of conscience, you have the right of self-determination, what is good and what is bad comes from the moral law, right? But unless there's an injured party that has standing in law to claim a right to a cause of action that you've caused injury or harm to, they can't do anything to you because you think you have the right to think. You have the right to think that, well, I don't need anybody's permission to hop in my personal property that I own, right? That I have the right to acquire, possess, and utilize my personal property how I see fit. If I want to claim and exercise that right to use my personal property on the streets and highways, which are free to the people to use, and we charge those involved in interstate and foreign commerce, that's who has to seek permission from us to tear up our streets and highways. Right?
Postal roads. Get it right.
Right. So, in the Senate, the section adopted read, "Congress shall make no law establishing articles of faith or a mode of worship or prohibiting the free exercise of religion." It was the conference committee of the two bodies, chaired by Madison, that the present language was written with its somewhat more indefinite, respecting phraseology. So, this is the beauty of doing research. And I'm showing you right now, folks, law.cornell.edu. This is from the annotated Constitution. You see that right there? U.S. Constitution annotated.
There it is.
Law.cornell.edu, Constitution. Con-An Amendment 1. This is Con-An annotated.
Mm-hmm.
Because that's what it says. U.S. Constitution annotated. Amendment 1, religion and freedom of expression, religion, an overview of why it says that Congress shall make no law, articles of faith, or a mode of worship, or prohibiting the free exercise of religion. So, my Health Freedom Idaho gals out there fighting those vaccine exemption forms for religious exemptions, there you have it. First Amendment. We don't need to make any law that says no, we can write an exemption. We don't even need a statute or a public act or policy that says that we can write one. It should be common sense. Congress shall make no law prohibiting the free exercise of religion. You want to exempt yourself from vaccines or any kind of medical procedure, medication, medical doctor claims there's a doctor, right? When they don't know nothing about what? Natural cures, remedies.
Mm-hmm.
These
That's
doctors
right.
don't cure you. They don't give you remedies for your ailments. Here's a pill. And then Congress is failing to do their job by protecting the people from something that may cause injury and harm to the people. Those evil designs, those malicious designs of men must be thwarted. Oh, yeah, Breaking Bad. I ain't going to go there. But anyway, so here you go. There it is. This is the reason why they don't have the power to make law. Because we instituted government to secure all of those unenumerated rights
Mm-hmm.
that fall under religion, the practice of religion, or even you don't even have to practice religion in order to claim these rights. All you have to do is say, these are my God given natural rights, unalienable, and are supposed to be self evident. And among those particular unalienable or unalienable rights is life, liberty, and the pursuit of happiness. That's not the extent of all of our rights. Now, here to go bust Agent 19's chops again. Here we go. Dealing with Field McConnell. Go back to that Fifth Amendment. Indictment by grand jury. The history of the grand jury is rooted in the common and civil law. Oops. Extending back to Athens, pre-Norman England, and the Aziz of Clarendon, promulgated by Henry II. A survey of the grand jury system, 10 REL revision 101, 1931. That hasn't even been that long ago. Relatively speaking, 1931. The right seems to have been first mentioned in the colonies in the Charter of Liberties and Privileges of 1683. Wait, 1683? Charters of Liberties. It seems that our founders were having some problems back then. It seems in 1603 there was some problems in England. It seems that we had some problems in 1215 in England. Anybody recognize the common theme? Have you done your studies on the history of law and the reasons why the Magna Carta was written?
Could that be that bar?
Why we have separation from Great Britain with the Lee's Resolution, June 7th, 1776,
Mhm.
ratified July 2nd. Why do we celebrate Independence Day on July 4th? Not because of the Declaration of Independence, folks. It's because of the Lee's Resolution. That's the document that separated us from Great Britain, not the Declaration. So, which was passed by the First Assembly, permitted to be elected in the colony of New York. In what? 1683, huh? Imagine that. This was done in, look at that. The Bill of Rights, a documentary history, 162, 166, 1971. Well, crap. I know when that was. Exactly, because that's when I was born. So let's see. That would be 48, almost 49 years ago. Not too long ago. That in all cases, capital or criminal, there shall be a grand inquest. Who shall first present the offense? Who shall first present the offense? Uh-oh. Busted. Dope. Included from the first in Madison's introduced draft of the Bill of Rights, the provision elicited no recorded debate or no opposition. So in other words, everybody knew at that time that yes, we you know, if it's an infamous crime, if it's anything over 6 months jail time, you got to go through a grand jury indictment. And the grand jury is the one that first brings the offense to the public. It's not supposed to be in the public eye until after, in the private, you go through a grand jury and you get a grand jury indictment. You have to get the consent of a jury. Imagine that in our form of government, you cannot deprive fundamental rights without the consent of a jury. Most often we're told, oh, well, yeah, that's the trial by jury. Well, that's a half truth. The other part is a grand jury. The trial by jury is a petite jury, 12 men. Grand jury is 25. That's the difference between a grand and a petite. So, the grand jury is an English institution brought to this country by the early colonists and what? Incorporated. Not a corporation. This is where I've discussed this before. Incorporated doesn't mean corporation. Okay? Incorporated means you're incorporated into the body politic. You're bound by it. Nothing to do with the corporation. In the Constitution by the founders, there is every reason to believe that our constitutional grand jury was intended to operate substantially like its English progenitor. The basic purpose of the English grand jury was, this is back to that basic Magna Carta due process of law, folks. The basic purpose of the English grand jury was to provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. Okay, Kim Picasio, you want fair process, a fair method. Why didn't you follow it? Both Tim and Field. Why aren't you following due process of law? You went to law school. You're deemed to know the law, right?
That's the claim, anyway.
Well, there's an extremely high presumption that she did go to law school.
Right.
There's an extremely high presumption that she's deemed to know the law, being that she's a well-known, prominent attorney, family law attorney in Broward, and I help people for free.
You remember that? Talking about that video, right?
Yes. The basic purpose of the English grand jury was to provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. That's so that we don't have jackwagons making false statements, getting their buddies sitting on the bench or behind a desk with a badge, exercising powers that are not properly belong to them.
You mean that shit made up?
That domestic violence, internal insurrection that I educated you about
There we go.
when you came to stalk me at the motel.
Right.
Oh, we came here to eat. Yeah.
Sure you did.
You came from, well, where? All over here to a motel to go to the restaurant in the motel. That's not that fancy of food. I mean, it was good food, but nothing to brag about, really. I mean, come on now. But anyway, grand jurors were selected from the body of the people, and their work was not hampered by rigid procedural or evidential rules. That's right. We want to know the facts. In fact, grand jurors could act on their own knowledge and were free to make their presentments or indictments on such information as they deemed satisfactory. Now, this is the part we were talking about in history where, oh, well, we can prosecute by information. No, you cannot prosecute by information. That's what happened right here. Why this was written was so that we didn't have some jackwagon sheriff's deputy writing an affidavit of truth claiming that he has a right to a cause of action and supplying information to a de facto kangaroo court to prosecute somebody. This is the reason why our founders wrote the Sixth Amendment the way they did, to stifle, to stop this from happening, because this is what was happening to them. They were being subjected to bills of attainder by somebody making this information available. Oh, John Boy over here did this. Oh, really? Oh, let me get on that. No affidavits of truth signed under penalty of perjury. Oh, well, we don't need that. We can just say that they did this, and oh, well, the statute makes this a crime. That's a bill of attainder. If you can't cite the right that was violated, that's called bill of attainder. That's legislation prescribes punishment. Well, if you do this, that's a crime. No, that's a bill of attainder, and that's pretended acts of legislation. Those are easy
made up.
statutable plunder.
Shit made up.
South Carolina's Constitution from 1776, unconstitutional, anal, oppressive statute, extending admiralty jurisdiction beyond their ancient limits.
Whew.
Kick frickin' rocks. I'm very passionate about our rights, if you can.
No, I would have never guessed that about you at all.
Just to re-clarify, I'm not yelling at anyone out there. This is just my passion. I've read the history, and I feel the passion that they had, right? Back then, reading this stuff, it's like, no wonder why people took up arms.
Right?
Okay? Because they remonstrated. So we cannot claim that we are under absolute despotism until we remonstrate, and our remonstrances have been met with repeated injuries. But I can tell you right now, we're starting to get somewhere in certain different states with these remonstrances. Okay?
Well, and again, remember,
it hasn't been exercised and practiced in a very long time, except for New Hampshire and Gus Brenton out there banging them out
right?
back in the day.
Yep. Hell yeah. You got that right. So,
okay. Despite its broad power to institute criminal proceedings, the grand jury grew in popular favor with the years. It acquired an independence in England free from control by the crown or judges. That's right.
Oh.
Its adoption in our Constitution is the sole method for preferring charges in serious criminal cases, shows the high place it held as an instrument of justice.
There you go.
What's the maxim of law? To deny justice is what?
Say that again.
The maxim of law to deny justice is to what?
You mean, well, justice is not for sale, for denial, or for delay. I don't understand what maxim you're talking about.
I can't remember. It's to deny justice, something. I know that right and justice do not abide.
No.
So,
Right and fraud do not abide together.
right, there we go. But there is it to deny justice something, there is a maximum of law. I actually have, I think it's in Tim's paperwork. I put it in there.
Justice is to be denied to no one.
Right.
It's in my paperwork.
Let's see. And so yeah, so here's the thing is that is justice. This is the process that's due to your fellow man. If it's a criminal offense that requires more than 6 months jail time, and get ready to read it. Here it goes. And notice that it has in serious criminal cases, shows the high place it held as an instrument of justice. And justice is to be denied to no one. There it is. That's the one that needed to come out. And in this country, as in England of old, the grand jury has convened as a body of laymen, free from technical rules, acting in secret. See, nobody's supposed to know about the grand jury indictment or grand jury hearing. And the grand jury has the right to call people in as a witness and quiz them and, ask them questions
Ruh-roh.
without anything to do with the court. This is an independent body of men, laymen, free from technical rules, acting in secret, pledged to indict no one because of prejudice and to free no one because of special favor. Where are our grand juries at these days?
That's a
They're
damn good
prescribed.
question.
Technically speaking, it's supposed to be in the House and the Senate. Those are supposed to be the grand juries, and that's right out of this book over here that I bought at the Supreme Court of the United States of America when I was there in September of 2018. Bills, Quills, and Stills.
Right.
The history of the Bill of Rights. The prescribed constitutional function of grand juries and federal courts is to return criminal indictments, but the juries serve a considerable broader series of purposes as well. Principal among these is the investigative function. Wait a minute.
You realize we've been going 2 hours and 42 minutes?
Have we really been?
Yeah.
This is the law for you. Computer, not bound by any evidentiary and constitutional restrictions. Such juries may examine witnesses in the absence of their counsel and without informing them of the object of the investigation or the place of witnesses in it. The exclusionary rule is incapable in grand jury proceedings, with the result that a witness called before a grand jury may be questioned on the basis of knowledge obtained through the use of illegally seized evidence. That would have to be addressed with a motion, right, for violations of fruits of a poisonous tree doctrine. It was unlawfully seized or illegally seized. I go with unlawfully.
Right.
So even though under a grand jury indictment, it could be said, but it's up to the grand jury to go, well, yeah, hey, there's other evidence over here that supports this, and this might have been illegally seized, but nonetheless, we're not going to cut this guy loose without a grand jury indictment. And then good luck to y'all out there. Make sure you take this to a trial by a jury. Maybe you can bluff a little bit and get this guy to settle out of court a resolution, or maybe even agree to arbitration. He may give his consent to arbitrate. But without it, that's a violation of due process of law.
It's still an emoluments violation no matter what. I don't give a damn what anybody says. Period.
Yep.
It's an emoluments violation because that bar card is a foreign emolument. It's got no standing in law. So who the fuck was she to walk in there and make a claim to begin with? That's one of those that's part of those long train of abuses and usurpations, right? Abuse of a fake emolument, usurpation of power that she ain't got. I mean, let's just call it what it is, dude. I mean, Jesus.
Yeah.
We're going to get passionate. I'm going to put feeling into that shit.
This goes right into the part about the Fourth Amendment, right? And thus allowing the use of evidence obtained in violation of the Fourth Amendment for grand jury indictments.
Right.
The court nonetheless restated the principle that Although free of many rules of evidence that bind trial courts, grand juries are not unrestrained by constitutional consideration. Okay, there again, if you're the defendant and you know that this was illegally obtained evidence, that somebody hacked your server, broke into your house and stole some of your documents, whatever. Okay, that's a motion to suppress that evidence that it was unlawfully obtained. So an evidentiary hearing and that kind of thing. So there you have it. The witness called before the grand jury. Let's go. So greater statements were two cases in which the court of the Fourth Amendment being incapable of grand jury subpoenas. Oh yeah, I love this part. Besides indictments, grand juries, listen up, folks. Grand juries may also issue reports. They may indicate non-indictable misbehavior, misdemeanors, or or malfeasance of public officers.
Could that be
This is
those
the beauty of
emoluments?
a grand jury.
Could that
Oh,
be
well, we're
those
complaining that
emoluments
so and so
violations?
did this, and then wait a minute. The law says you as a public servant can't do that. That would be mis or malfeasance of a public officer. Guess what they write, or other objectionable conduct? They write in a separate document, right, that these are non-indictable misbehaviors because they're not felonies and they're less than 6 years jail time. Okay. They can write this in there and say that these are non-indictable offenses, but still can be gone through as emoluments violations, as a criminal offense, a public
Uh-huh.
offense, as a public
And
servant. Despite the
removed,
vast power of grand juries, there is little in the way of judicial or legislative response designed to impose some supervisory restrictions on them, on grand juries.
right?
And this is the power of the people.
Yeah,
Remember, these are supposed to be us, the laymen,
that's right.
not elected officials,
So
not
first,
court chosen grand juries.
yep. So pull up your state's organic act, right? Your organic constitution, the original one, and say, show me in this document right here where it says you can create this emolument. Show me that. Because if it ain't in here, it's one of those multitudes of offices to send hither swarms of officers to harass our people and eat out our substance under this policy, political argument bullshit. Get that garbage out of here. So, how many different flavors of no do the justices have to tell these damn bar members? I've counted more than a few since I've started this.
Right.
So,
So here it is, folks. Within the meaning of this article, what do you mean article? Article the 6th, not the 6th Amendment.
oh, there it
Somebody
is.
let that one slip through.
Whoops.
Within the meaning of Article the 6th, a crime is made infamous because when it's in all criminal offenses, capital and infamous crimes, this is where Agent 19, this is where we busted his chops right here. We schooled him right here. Within the meaning, well, it says infamous? Yes, it does. In all capital or otherwise infamous crimes. Well, what does infamous mean? Well, you're about to find out here, which we told you, Agent 19. Dope. Dope. Who got schooled again? By the quality of the punishment that may be imposed. Ex parte Wilson, 114 U.S. 417, 1885. And like I told him, this has already gone to the Supreme Court, already been decided and said what an infamous crime is.
Ooh.
Well, that's only for the death penalty. No, that's the capital or otherwise infamous crimes. Infamous. It's not
Right.
real famous to commit these crimes.
Right.
Like, I don't know, kidnapping, rape, assault. Battery. What punishment shall be considered as infamous may be affected by the change of public opinion from one age to another. Okay. Imprisonment in a state prison or penitentiary with or without hard labor, or imprisonment of hard labor in the workhouse of the District of Columbia falls within this category. The pivotal question is whether the offense is one for which the court is authorized to award such punishment. Oh. The sentence actually imposed is immaterial. When the accused is in danger of being subjected to an infamous punishment, if convicted, he has the right to insist that he shall not be put upon his trial except on the accusation of a grand jury. Thus, an act that authorized imprisonment at hard labor for 1 year, as well as deportation of Chinese aliens found to be unlawfully within the United States, created an offense that could be tried only upon indictment. Oh, wait, it can only be tried only upon indictment. Counterfeiting, fraudulent alteration of poll books. Whoops. Fraudulent voting and embezzlement. Emoluments violations have been declared to be infamous crimes.
There it is right there.
It is immaterial how Congress has classified the offense. An act punishable by a fine not more than 1,000 or imprisonment for not more than 6 months is a misdemeanor, which can be tried without indictment, even though the punishment exceeds that specified in the statutory definition of petty offenses. A person can be tried only upon the indictment as found by the grand jury, and especially upon its language found in the charging part of the instrument. A change in the indictment that does not narrow its scope deprives the court of the power to try the accused. Although additions to offenses alleged in the indictment are prohibited, imagine that. The court has now ruled that it is permissible to drop from an indictment those allegations that are unnecessary to an offense that is clearly contained within it. So if you got like some fringe stuff on the outside, then like you could be charged for this, this, and this, we're gonna drop that stuff. I'm gonna stick with the clearness of clear and plain language of the indictment. There being no constitutional requirement that an indictment be presented by a grand jury in a body, an indictment delivered by the foreman in the absence of other grand jurors is valid. If valid on its face, an indictment returned by a legally constituted, non-biased grand jury satisfies the requirement of the Fifth Amendment and is enough to call for a trial on the merits. It is not open to challenge on the ground that there was inadequate or incompetent evidence before the grand jury. Right, because that's all done through other procedure. The protection of an indictment by grand jury extends to all persons except those serving in the armed forces. All persons in the regular armed forces are subject to court martial rather than grand jury indictment or trial by jury. Are we really getting that bad? Why doesn't this mouse run this screen?
Whoops.
All right. I think I laid that out there pretty good there. And y'all can go read up on that for yourself.
I'm going to give you the short version here, right? So we've already discussed the law. We already know what your political power is, where you exercise it. What is your political power over or on top of? One little word. There it is. Right there. So that is where your political power is. So you want to remove them from duty, from that emolument of that office. There's only one house that has or one group of set of men that has the power to do that. That's the legislature, right? If there's something they're using that is not lawful, Title IV et al. Wink, wink, nudge, nudge. Obamacare. Wink, wink, nudge, nudge. get your remonstrances into the legislature challenging the validity of those emoluments. We've already put as much of this information out there for you guys. You say, hey, I'm here and I want to stand with this guy, right? And again, that's why I said they want to play contract. And one last little final thing before we go on that. Whoops. When I did my notice of appearance, right? There's that notice of appearance, right? Head of household on Groundhog Day, the man doing business as this corporation, right? Incorporated, showed you where all that came from, right? Remember those false statements that Kirk was talking about at the beginning of the show, right? Because that's in print, right? That's called libel and it's a falsehood. What does the law do to that? The law punishes that, right?
Yep.
So the definition, a published false statement that is damaging to a person's reputation, a written defamation. There
Yep.
it is, right? And remember,
And
this is in my notice of appearance, mind y'all. So,
right. And
they know I'm coming in here because of this freaking problem. I've
and
been
then
telling them this since minute one.
mhm. And then slander is verbal.
Yes,
So
slander is
libel is
verbal.
the written, slander is the verbal. And see,
This office does
this is where
business.
somebody should have been filing under that right to a cause of action, under libel and slander.
That was the other one. The other one was a usurpation, right? This is doing it the proper way. This office does business hunting, like hunting rabbits, for following red flags in both public and private sector corporations pursuant to Article 1, Section 9, Clause 8, aka Foreign Emoluments Clause. We are going to define this goddamn thing if it kills them, and it just might. But anyway, I digress. But there's my notice of appearance. I've been telling them this since the word go. So there are no surprises here, right? No shit made up on this one. So we're here to talk about emoluments of government. We're here to talk about libel. And we are here to discuss, oh, there's that thing right there. Where does that fiduciary duty lie? Right? Basically, whose foot am I going to break my manly firmness off in? Or
Right?
whose anus am I going to break my manly firmness foot off in? So
Would that be your anus or their anus?
exactly. Just saying. So
All right. Sorry I rattled on, folks, but
no,
this
you're not.
stuff
Don't
just
lie.
winds me up, and especially when I know, my fellow Marine is being subjected to this tyranny
Yep,
by
pisses
a
us off a
bunch
little
of
bit.
corrupt people. And in my mind, I think they're corrupt.
Yep, I think it pisses us off just a little bit. You want to keep this fire going? You want to keep Kirk rattling on for hours and hours and hours? Here's how you do that. Help a brother
Please,
out
please help
because,
support this.
yep, he is going to we are going to make damn sure we're going to go in there and kick the emoluments out of these little bastards. Right. So, yes, if you guys, I mean, hey, we're doing what we can do from the perspective we're doing it. There have been, we're even dealing with the whole, you know, uh, am I going to be showing up down there in Broward County? Eventually, yes, that's going to happen, by the way. Which cause of action?
What are you?
Who
Are you saying you
knows?
haven't yet?
Well, again, because of
I'm just
events that
saying.
have transpired, right? Right now, we're just in the reporting phase, right? So if they want to handle their own emoluments problem, hey, again, right? More power to you. But if I have to come down there and do it, somebody's not going to be having a good day, right? So, and of course, there's all the states that we're collectively working in. So just to have a little bit of fun with that. Um, but we are going to horse around in the after show here a little bit. I'll put the number up there.
Yep.
Don't
So
know for how long because of tonight's rambling on, but
right. Oh crap! That's what 12:30 your time. Man,
right,
I'm all of a sudden getting warm over here.
right.
I am seriously. I got this long sleeve
So
shirt and my jacket. I don't even have the temp turned up, and I'm
yes, we're gonna have
got
to round
fired up.
P. Gonna have to round P and head for Q a little
Right.
bit here. So give us a couple of minutes once we sign off. After that, you guys can feel free to join us in Zoom. And
So, just want to let everybody know out there, episode 2, I will be redoing episode 2 to include, I basically knew that stuff there. I just didn't have that as reference material at the time. And I'm also when I go to redo episode 2, I'm actually going to show how to do a uh, notice of appearance, because that's the title of the document. You're appearing specially or generally, but the title of the document is a notice of appearance.
mhm,
And then how to do the motion for dismissal, how
right,
to do the brief, memorandum of law with points of authority, and a proposed order. So I'm sure many people will enjoy that. I know I've had several people go, "Oh, you need to have that stuff in episode 2," and I'm like, "Yeah, I know I didn't have that at the time.
right.
I just remember reading in Beauvair's Law Dictionary
Mm-hmm.
under the cause of action, you have to have a right that was violated
Right.
in order to have a right to a cause of action." And I'm like, well, that makes sense. What's the name of the man who is standing in law to claim a right to a cause of action here?
There you go.
Before common sense, before I had the common law pleading book,
Right.
before I had any of that. That was just common sense to me by reading what a cause of action is.
Thank you for reminding me before we go. I want to let everybody know I'm getting ready to redo this video. What is E-clause as a defense contractor in law? Right. So this will be set up, posted on YouTube, and linked through the Patreon site. Right. So that's why I said there's going to be some kind of bouncing back and forth between the Patreon site and YouTube. And, you know, I'm trying to, because I understand there's a lot of people out there that don't want to do Facebook because of the politics shit. And I get it. I understand that. So, you know, having having gone through and you guys have watched what Kirk and I go through, we don't blame you for not wanting to not wanting to go that route. So I'm kind of
Right.
trying to branch this out into multiple areas for you guys. So and one of the reasons Patreon is going to work well, number one, is it provides to upload files and link to different websites, kind of
Nice.
centralize this stuff for you guys. And it also, because of the nature of it, if somebody wants to, sign up to be a Patreon and be a troll, well, that's going to cost them. So that's the hilarious part about it. So they're going to have to pay to troll. I just think that's hilarious. So, but anyway, that's what's coming up with Patreon, and the girls are working on working on some of the stuff, but I still have to narrate the PowerPoint. So again, it's in the works. There's all kinds of stuff going, as you can see. I got one of the computers here for the girls. It's a sick one. I'm trying to put it together for her, and
Yeah.
it's coming. So
I just want to thank everybody for tuning in on Facebook and YouTube, the likes,
mhm.
the follows, the shares, all that good stuff on Facebook, and the subscribers on YouTube. Thanks for the
Mhm.
support over there. Do the thumbs up if you're on YouTube up there. Do that, please. And then share, of course. Share everywhere.
Yes.
Share with your family, share with your friends. and share with the non-Americans.
Mm-hmm. Thank you, Melissa, for posting the redress for dummies. We're going to get that updated again. Got some more stuff coming out there on redress for dummies. So,
Actually, Gus sent me some stuff. I need to look into it and do some reading on it, but haven't gotten to
cool.
it yet.
Cool.
So thanks to Gus Breton out there that did the redress for dummies WordPress out there for eclaws.org.
Yep.
.com.
Yeah. Morons.
Jackwagon troll out there who's trademark infringement
Mm-hmm.
in an attempt to what? Libel,
Disparage and
slander,
libel. Yeah. Libel.
e-clause.
Mm-hmm. So
Your due process of law is coming, gentlemen. Make no
we
mistake.
know how to, maybe because we know how to follow that.
Right. We don't want any real bad criminals out there getting off on technicalities.
Nope.
I'm not going to violate your right to due process. I'm going to follow due process of law.
But I'm going to exercise mine, trust and believe.
That's right.
So, and I know how to do that, and I'm really good at it. So,
All right, folks, here we go. Much love, everybody, and we will see you on Friday Night Fun Night. But we'll also see you Wednesday Night Live.
I was going to say, I'm going to carry the 2 Wednesday-ish.
Well,
I got it. Okay.
It might be a true statement, Friday Night Fun Night.
Right. You got that right.
I can't foretell the future.
Right.
All I can say is I hope to be here, and I hope to be...
Oh, we'll be here.
I don't know. Hip to be square.
I have a feeling we're going to be here.
All right. So much love, everybody, and have a wonderful night. And we'll catch you on the flip side over there on Wednesday Night Law or Wednesday Night Live.